litigation. Let me start with the plaintiffs.
One preliminary matter, so obviously JL and BL you've already held in default. Mr. Harrison is a member and could be called as a corporate representative as well, just for judicial economy. If I did have any questions, just to get on the record, just membership, some of the factual allegations, would you like me to just leave him up there and recall him as a corporate representative, or?
No, I think you just note for the record that the next line of questioning will be in your role as a corporate representative. All right. And similarly, just as a heads up on the issue of attorney's fees, again, my understanding is under 13-611, the sum total of your attorney's fees expended in this case are relevant and can be introduced in your case in chief. It's just what justifies them is confined to leading up to the beginning and commencement of the lawsuit. So to that end, if you had evidence of attorney's fees you were planning to submit, I think, again, the amount would be relevant for today. I know you had talked about maybe it was referenced elsewhere in the pleadings, but for now, as I mentioned, I think that for purposes of notice and argument, that we would confine the application of those fees just to 13-611. And if you feel the need, or if there's a legal justification still remaining after the judgment in this case to pursue alternative theories, then you can make that appropriate motion.
Yes, Your Honor. And I believe that everything so far, the testimony facts presented all relate to how the contract was entered into. Knowledge, I think 13-611 should be sufficient and would include, to my understanding, then we could seek, of course, all attorneys, personnel fees, and court costs as well.
Understood. And so the clarification, I think, or the distinction there would be the alternative theories would be, as you mentioned before, the conduct post-suit of the other, TPOs or just conduct in the litigation to the extent that's relevant or applicable. So just so I think we're clear there. All right. Anything else?
No, I do believe that when we get to the point of attorney's fees, I might need a brief recess to remove then any of the related lawsuits from our total sum.
I think it would be important to make that distinction clear for the purposes of the record. All right. Anything else?
No, Your Honor.
All right. Mr. Harrison, anything you want to take up before we get back into it? All right. Well then, sir, if you can make your way back to the stand, we'll resume your examination by plaintiff's counsel.
Your Honor, if you don't mind, just 1 minute. The other plaintiff asked if I could send the Zoom link. I did not even think of that when
I believe we are live streaming this, so she can also just go on our court's YouTube channel. Question.
Or I can. Do you know the address? It's just on your page.
That's right. And I think we generally wouldn't let anyone into the Zoom call unless they were a witness or needing to join it. Just FYI.
It's just Amari and Miles, Your Honor.
I understand, but we just try to keep the Zoom call fairly clean. So it's going to be, apparently it's at Judge Scott McAfee. So it's live streaming right now.
Sorry.
And just while we're planning out the scope of this morning, Mr. Harrison, following up on where we ended yesterday, other than your narrative testimony At this time, do you believe you're going to be calling any additional witnesses for your case?
No.
All right, thank you for that update.
I would still also like to preserve my objection for lack of jurisdiction.
Oh, it's certainly,
Subject matter.
yeah, it's certainly preserved. No question about that.
I did have a question on that, Your Honor. It was my understanding that you ruled that you did have jurisdiction. So just for clarification, is Mr. Harrison preserving his right to appeal that specific decision, or is he reserving? I thought that you had already ruled at the beginning of trial.
I did. I mean, I denied it. And so to the extent he decides to appeal, if there is one, a decision of this court, then I think that issue itself would be preserved.
Thank you. All right. We left off yesterday, or good morning, Mr. Harrison.
Morning.
Left off, I believe, with January of 2022 with regard to the IRA, the balance being withdrawn and the account closed, correct? With your IRA account.
Repeat that question.
We left off yesterday with the IRA being fully withdrawn and closed as of January 2022.
I told you I'm not sure of the dates. I'm not sure of the dates.
I'm gonna circle back. I can circle back to the IRA. I don't believe it's necessary at this point. However, for today, let's start with the year 2020, when your parents passed away.
Okay.
Isn't it true that you were assisting and or in control with your parents' finances at that time?
No, I wasn't in control of it.
Is it true that you assisted your mother with the rollover of your father's IRA?
What?
Is it true that you assisted your mother with the rollover of your father's IRA, the transfer of his IRA after its passing into your mother's account?
My sister and I both assisted with that.
These documents were provided to you yesterday. These are additional Wells Fargo documents.
Again, you point to whatever page you're trying to get to. There's a lot of documents here.
Right, so this is the account, this is the rollover from your father's account into your mother's account.
Okay.
I'd like to submit plaintiff's exhibit 5.
Well,
These are
if we're gonna,
additional
before we
Wells Fargo
submit it,
documents.
I want to look at them then.
Okay. Your Honor, I believe that the packet of exhibit 4 was not fully complete because there was still part of it on the table after. But I can make sure to give you the full copy today. Just wanted to note that.
But the most important aspect I'd be wanting to make sure is that our court reporter has the full copy as well. All right.
Yes, of course. And we spoke last night regarding that.
All right, because the copies you give to me, I'm keeping, and she should have her own independent copies, right?
Yeah.
All right.
Take your time. you have any objection?
No.
All right, so if there's no objection to P5, then they are deemed admitted.
Can hold on to them?
I'm good with projection on the screen.
Oh, okay.
May I approach? This, the link for publishing the exhibits, is that also the new link for sharing my screen today then? The Zoom link, because the one from yesterday
That's
is,
the email I sent out this morning.
right, so I'm going to share plaintiff's exhibit 5 on the screen for you, for everyone. And this is the Wells Fargo account dealing with the transfer of Mr. Harrison Senior's IRA into the late Mrs. Harrison. All right, so Mr. Harrison, isn't it true that this first page that I'm showing on the screen right now, this is dated April 27th, 2020?
There's something in the middle of the screen, so I can't.
Just press that.
Oh, okay. Should I press the screen?
Yeah, stay muted. Or
Oh, okay. Yes.
And based on the notes here, would you agree that this is the submission of the death benefits for the IRA of the late Mr. Harrison?
Yes.
Isn't it true that this is the death certificate for the late Mr. Harrison?
Yes.
Isn't it true that you submitted this to Wells Fargo?
I mean, we all submitted it. It was me, my mother, and my sister.
Isn't it true that you were the one who individually sent that paperwork in.
No, I don't think I did. I can't recall 2020. I can't recall who actually sent the paperwork in. It was me, my mom, and my sister who was sitting down dealing with it.
Would you agree that your father's IRA had a substantially larger value than your mother's?
I didn't know anything about my mother, so I don't know what was in hers.
But isn't it true that you received your mother's, including the account paperwork that was then rolled over into your individual IRA?
Repeat the question.
Isn't it true that you received your mother's IRA, including the account paperwork?
I did not receive all account paperwork from my mother's until we subpoenaed it for this lawsuit.
Isn't it true that your father's IRA had a significantly larger value than your mother's?
I don't know how much was in my mother's to begin with.
Would you agree that if you received approximately $159,400 and some dollars, and you knew the amount of your father's IRA, which I will show you, but that you would then know that your father's IRA was worth significantly more than your mother's?
I don't recall how much was in my father's to begin with. As a matter of fact, I don't remember how much was in any of it because it was it was a lot of different beneficiary or IRA forms that we were dealing with. We were specifically dealing with my father. Me, my mother, and my sister were dealing with my father's insurance and things like that after he passed, which was 8 months prior to my mother. So anything dealing with my mother's IRA was not something that we were discussing at the time.
I'm not asking about your mother's IRA. I'm asking about the difference in value between your mother's IRA and father's IRA. So
But that's actually a question about my mother's IRA. So I would have to know the value of my mother's IRA. And like I stated, I don't recall. This was a tough time for me as well. My father had just passed away. At that time, there was COVID. There was a lot of stuff going on, and everything was in disarray. Everybody was distraught, but we were trying to deal with whatever had to be done to keep my mother going because COVID was shutting everything down. So I don't recall all the specifics of how we dealt with anything. I just recall me, my mother, and my sister sitting down, contacting them. What I do recall is that it took maybe a month or so for her to get any kind of return call back from Wells Fargo because of COVID. I do recall me, my mother, and my sister sitting down, planning to drive to Birmingham to try to talk to Wells Fargo to get that straightened out before COVID shut down. But I don't recall any exact amounts that would have been in that IRA versus my mother's IRA.
sorry, just 1 second. I'm trying to. Based on this document, would you agree then that your mother is signing, attesting that she is the primary beneficiary for your father's IRA on approximately April 15th of 2020?
I can't see the first document. You're asking me about the signatures. I don't know if that's my father's IRA. I don't, you scroll past those pages.
Would you agree this is the IRA beneficiary claim form?
Yes. It says spouse, correct.
This is the first page of the claim form.
Okay.
And given that that is the beneficiary claim form, would you agree that your mother executed it then on April 15th, 2020?
Okay, that seems correct.
Would you also agree that this is the affidavit of domicile?
Yes.
Isn't it true that the notary reflected here, Vaughn Lawson, is also the notary on every single other documented issue in this case that is notarized?
I'm not sure if she notarized every document, so I don't know that for a fact.
Isn't it true that she notarized all of your documents claiming the IRA funds?
I believe she probably did.
Would you agree that, and this can be based on your recollection even, your father's IRA had a death benefit, a guaranteed death benefit of approximately $132,000?
I don't see that on this document, so I don't know what you.
As it
I
based
don't
on your
agree.
best recollection, would you agree?
Oh, I cannot recall. I've already testified. I do not remember what was in his.
Sorry, just give me one second. I'll go back to what I originally asked. So would you agree that you did assist your parents with their finances in general?
I didn't assist my parents. I assisted my mother. I assisted my father with taxes over the past few years prior to his death.
Would you agree that taxes are also financial documents?
It's part of finances.
And when your mother's IRA, or well, when she received your father's IRA, it would have been roughly April or May of 2020, is that correct? May, I guess May.
Somewhere around there.
And then approximately 6 months later is when you received notice that you were the primary beneficiary in your mother's IRA, correct?
I received notice that I was the sole beneficiary around December. So I guess that might have been
That's
7.
not what my question was, Mr. Harrison. Isn't it true that approximately 6 months after your mother received your father's IRA, that you received notice that you were the primary beneficiary of your mother's IRA?
That was probably about 8 months.
It was just your testimony that it would have been approximately May of 2020 that your mother received your father's IRA, correct?
I think it was April from what you just showed. What you just showed
You
was
agree that what I just showed was the beneficiary claim form on April 20th of 2020?
I can't recall if it was April or May. So if it was April, when I received notice that I was primary beneficiary, would have been in the middle of November. So if that's 6 months, 7 months.
Isn't it true that your mother passed away on November 3rd of 2020?
That's correct.
And isn't it also true, which I do know we covered yesterday, but isn't it also true that it was no later than I believe November 17th, possibly November 19th, that you submitted everything to claim the contents of your mother's IRA?
About November 21st, I think, the 20th or the 21st.
All right, I want to jump in here and I just want to provide plaintiff's counsel notice based on how things are going. However you want to use your time, that's up to you. But we're going to end the examination at 10:30. All right? So you have 1 more hour remaining.
That's plenty of, thank you, Your Honor. So after you received notice that you were the primary beneficiary on November 25th of 2020, isn't it true that you then either engaged with directly or contacted, his name was Clovey, in order to look into selling the property?
I believe it was towards the end of November.
Isn't it true that you did not immediately tell Ms. Harrison that you had discussed selling this property?
No, that's not true. We discussed selling the property, and I told her I was going to reach out to Clovey, which is someone we had both dealt with earlier that year. She dealt primarily with Clovey. So that's the only real estate broker that I know. So that's who I reached out to. She was supposed to be reaching out to other brokers herself because she says she deals with real estate. That's what she says her occupation is. So she was going to reach out to her contacts.
Just for clarification, that's who said whose occupation is.
My sister said that she deals with real estate. She flips houses. She was going to reach out to some of her contacts about selling the house.
I just like to, one, object to that statement, but note for the record, that is not what the testimony reflected. I'm not going to go through the wordage. Based on your testimony, isn't it true that you and your sister started negotiating this purchase and sale agreement on or around December 8th?
The current purchase and sale, buy-sell agreement between co-owners that we have.
Yes.
Yeah,
That one that you executed, signed, and in it. Correct.
we started negotiating around December 8th.
And this exhibit is of the record. This is the purchase and sale agreement. And based on your testimony yesterday, isn't it true you stated you were unsure if the 10% penalty and IRA calculations were contained in the contract?
I stated I was unsure how it was how it was stated in the contract. I don't know if it was combined or if it was actually broken up. So now, and I asked you, can I see the contract, which you didn't let me see yesterday, but now though I do see it, I do agree.
Is it true that you did not have a tax bracket of 35%?
No, it's not true.
Your testimony, just for the record, is that your tax bracket is 35%.
At the time of signing this contract, she was going to be relinquishing her interest to me, at which I have 10 years to withdraw. When we spoke about it, my tax bracket fluctuates because I'm self-employed. I have a wife that also earns over $100,000 a year. So between the two of our incomes, our tax bracket fluctuates. So if I'm going to withdraw money on 1 year, my tax bracket may be one amount. If I withdraw money 5 years, it may be another amount. So when we negotiated if she's going to relinquish her interest to me, and I'm going to withdraw everything for me to be able to net $130,000, we would need to account for the taxes. And
But
we
it's
came up
in-
with a formula.
In 2020, your tax bracket was not 35%.
But this wasn't just for 2020.
Would you agree that that clearly states the mandatory income taxes of 35% and the withdrawal fee of 10%?
It doesn't state for 2020.
That was my question. Would you agree that that states the mandatory income taxes?
Yes, I agree. That's what it says.
And I believe we established that it was January of 2022, which I believe we'd already showed was not a lot, but in 2021, isn't it true that you withdrew nearly all of the IRA?
Yeah, that's true.
Isn't it also true that in the year 2020 and the year 2021, your tax bracket was not 35%?
No, I don't recall what my tax bracket was in 20 or 21.
But wasn't just your testimony, your tax bracket was not 35% in 2020?
I said, I'm not sure what it is, but the contract is based on me withdrawing the money out over 10 years.
But would you agree that the money was not withdrawn out over 10 years?
I do agree it was not drawn out over 10 years, but it was contemplated that I had the opportunity to withdraw it over the 10 years, which is the maximum length that I could withdraw that money.
Would you agree that that contract does not state anywhere that it would be withdrawn over a 10-year period?
It doesn't state that, but that's what we negotiated, and it's at the end of the day, that's what we negotiated. That this was the amount that we negotiated and that we discussed when we calculated this particular formula. Because if I had 10 years to withdraw it, my tax bracket may have been different in 5 years than it was in 1 year. So if my tax bracket was different in 1 year and I had to pay more taxes a particular year, then I would be losing money, which we discussed thoroughly while we were discussing this contract through text messages the night before.
Would you agree that you submitted no evidence that you ever actually paid any taxes on this IRA?
I do agree I haven't submitted any evidence. I wasn't asked to submit evidence.
So your testimony was just that while the agreement didn't state it, essentially, would you agree that your testimony was, you did not state it was over a 10-year period, it was contemplated, but this is what you contracted for? I'm just asking a general question about your testimony.
I didn't contract to pay 35%. I don't understand what you mean. It's part of the contract, which is determining the actual cash value of the IRA. So to determine the actual cash value, we had to come up with the amount that was minus taxes because an IRA is not all cash. An IRA, you have to account for taxes, whether you take it out at the time you withdraw it or you pay later through the taxes.
Yes, that was not my question. I do appreciate the response, but it was, would you agree your testimony was that while you did not include a 10% or sorry, 35% of taxes being withdrawn or contemplating 10 years of withdrawal of the IRA, that this agreement is still what you contracted for?
Yeah, this is the contract. This is what we contracted for.
And would you agree that you contracted for your sister to receive and be credited for a 50% share of the IRA less mandatory income taxes of 35% and the withdrawal fee of 10%?
I agree that it says purchaser agrees to relinquish her interests in the above mentioned inherited IRA and then apply that amount towards the total purchase price of said property. The first part of that was she was to relinquish her interest to me. So once she relinquished her interest to me, which is called disclaiming, if she would have disclaimed her interest to me, the whole IRA is mine, at which time I'm responsible for all taxes of the entire IRA, which had to be withdrawn no later than 10 years.
But isn't it true that you already received notice you were the primary beneficiary on November 25th, 2020?
I received notice I was a primary beneficiary, which there could be multiple primary beneficiaries.
Isn't it true that you received an email with a document attached listing only you as the beneficiary, the primary beneficiary with no contingents at a 100% of benefit value on November 25th, 2020?
I've testified that I did not see that attachment. What I saw was the text of the email, which responded to my question, was whether or not I asked a question about the primary beneficiaries or contingency beneficiaries, simply because my sister had claimed that there was an issue between her being listed as a contingent beneficiary as opposed to primary beneficiary or something like that.
I would object to that. There was no testimony your sister ever claimed or.
All right, unless it's in the form of a question, you just have to bring up your contentions with his testimony in summation.
Isn't it true that your sister never testified that she thought she was a contingent beneficiary?
No, she didn't testify that yesterday. But she did tell, what is she?
Isn't it also true that you then later learned, after your sister tried calling Wells Fargo, that she was told she was not a beneficiary?
What I later learned was that she told me that she was the sole beneficiary, that she was a joint beneficiary. She told me that she had spoke to them. They got whatever issue they had straightened out between being a primary and a secondary beneficiary. She told me that she was a joint beneficiary and she wanted to buy the house using her interests as a joint beneficiary.
Is it true that you told her, your sister, Miss Harrison, that after she learned that she was not a beneficiary, Wells Fargo could not speak to her, that it must have been a mistake because you and your father had the same name?
No, that's absolutely not true.
Would you agree that Ms. Harrison testified that you stated that?
Yeah, I agree. She testified to that.
And would you agree that, based on the records we reviewed yesterday from Wells Fargo, the email communications, that you received notice prior to the execution of this contract that your benefits were the full benefit was being processed and released?
No, I do not agree to that.
Would you agree that there was an email stating that within approximately 10 to 12 days, you would be receiving full benefits of the late Ms. Harrison's IRA?
I received an email telling me I would be receiving, I can't remember what the exact email states without looking at it, but I do recall receiving an email telling me that my claim would be processed. within 10 to 12 days.
Would you agree that after the passing of your parents, nearly all of the assets were retained by you?
No, I do not agree.
Would you agree that the house you currently live in was purchased by your parents and then later deeded to you?
I agree that they helped me purchase the house in 2009.
And would you agree that you received the entire amount of your late mother's IRA?
I do agree to that.
And would you agree then that you then entered into a contract with your sister for her to buy out your interest in the property at issue in this litigation?
No, I do not agree to that.
Isn't it true that this contract you have already testified to is the contract you entered into for her to buy out your interest in the property?
Well, what you stated was that I received the full amount from my mother's IRA, and then I entered into a contract, and I do not agree to that. I was not aware that I received the full amount of her IRA prior to entering into a contract with Mrs. Harrison.
The question was, isn't it true that you also entered into a contract with your sister for her to buy out your half interest in the property at issue in this litigation?
Yes, I do agree to that.
And isn't it true that on December 28th of 2020, you received confirmation that the full IRA funds were reflected in your personal account?
December 28th?
Yes.
Yes, I agree to that.
And would you agree also that you responded also on December 28th of 2020 that you saw that your account balance reflected the full benefits of the IRA?
Yes, I do agree.
Would you agree that the first time you gave notice to your sister that your accountant, CPA, lawyer, and I believe it was CPA and lawyers first discovered that your sister was not a beneficiary in March 2021?
No, I do not agree.
Isn't it true that you had an attorney send a letter to your sister in March of 2021?
I do agree to that.
Not that, but that stated that we just discovered that she is not a beneficiary of the IRA and therefore owes an additional, I think it's 42,350 or maybe 43,250.
I agree that I had a lawyer send her a letter in March. I cannot remember what the exact wording of the letter is, but it was March when I had a letter after extensive conversation with her prior, with
Isn't it
no
true that
response.
that letter was sent on behalf of you individually?
Yes, yes, I agree.
Is it also true that in February of 2021, you formed an entity called JLNBL Investments LLC with you, Lisa Harrison, your wife, and Michael Harrison, your son, as the members?
Yes, that's true.
Isn't it true that you conveyed, after entering into this purchase and sale agreement, your interest in the property subject to the purchase and sale agreement to JLNBL Investments LLC?
I convey my interest in the property based on the fact that whatever third party, there's a clause in here that states you can convey your property to a third party as long as they adhere to all the terms of the contract. So if that's what subject to means, yes.
And isn't it true on March 17th, 2021, Mrs. Harrison wrote a check for her first quarterly installment payment of $19,217.
I don't know if she wrote a check. I think it was a cashier's check, I believe.
Okay, so you received a check for the first quarterly installment payment, correct?
Correct.
And isn't it true that in that same communication, in response, after receiving the check and depositing the check, you thanked her for receiving it?
Correct.
Isn't it true that the funds were to go to JLMBL Investments as the holder of the interest of the outstanding interest in the property?
No, it's not true.
Didn't you just say that the contract says you can convey it to a third party subject to the terms of the agreement?
That's correct. And the terms of the agreement says that the purchaser, Marilyn Harrison, is to pay James Harrison, who's a party to the contract.
Would you agree that if a contract is assigned to somebody else and that contract requires payments, that the individual or entity it is assigned to is entitled to receive those payments?
I did not assign the contract. I quit claim the deed. The contract was never assigned, which requires writing or some kind of agreement. This was a personal agreement that I quit claim the deed from myself individually to my LLC, to which Ms. Harrison did not know about. So the contract never changed.
But you just testified that you could convey it to a third party subject to the terms of the agreement, correct?
Correct.
And you also testified that the members of the LLC are you, your wife, and your son, correct?
Could you please scroll down to that clause?
I'm asking a specific question. You just testified that the members of the LLC
Correct.
are you, your wife, and your son, correct?
Correct.
And would you agree that as a member of the LLC, that you knew about the terms of the agreement?
Absolutely.
And would you agree that you knew this was an installment contract and that all installments had not been paid?
Yes, including the balance from the IRA had not been paid.
That is not my question. I was asking specifically, would you agree that as a member of the LLC, you knew that the contract was an installment contract and that not installments had been paid?
Correct.
Yet, after conveying the property to an entity you formed without giving Ms. Harrison notice of that entity, you still accepted payment under the agreement, correct?
Correct.
And isn't it correct that you are the managing member of that LLC?
No, I'm not the managing member anymore. At the time, I was.
Isn't it true that you and, well, through counsel, you as a representative of JLMBL Investments consented to the TRO in the present litigation in June of 2021?
I consented to the TRO.
Isn't it true that you retained counsel both individually and on behalf of JLMBL Investments?
I mean, I can't speak on behalf of JLMBL.
Isn't it true that you executed the retention agreement for William Downs to represent you and JLMBL Investments?
Yes, I did.
And isn't it true that you individually and on behalf of the LLC gave your authority permission to execute on your behalf the consent to the TRO at issue in the present litigation?
To the consent, yes.
Isn't it true that that TRO was also consenting to the remaining installment payments to be paid into the registry of the court?
Yes.
Would you agree that yesterday we established that in April of 2021, that you had filed a TPO against your niece, Miss Amari Harrison?
Yes,
And would you agree that you filed numerous other lawsuits against Miss Amari Harrison, Miss Harrison plaintiff, her son who testified yesterday, Miles Carter, and her fiance, Rep?
I filed claims. Yes, the only lawsuit was over the conversion of the car that's titled in my name that they're not paying me for returning. Everything else was a family court matter, except for this lawsuit.
Would you agree that a temporary protective order seeking immediate relief is filing suit? Is seeking the court to enter an order in favor of whatever relief you are seeking?
The relief I was seeking was the key, which she granted, which you refused to give. And so if that's considered a lawsuit, I guess so.
This is plaintiff's exhibit 11. This is a combination of the original order, the bill of peace entered on February 3rd, 2023, and then the amendment.
This should include the appeals on it, shouldn't it? This is in appeals right now.
Do you agree that if there's no appeal docketed, that there is no pending appeal?
There's a notice of appeal on the record. And if the notice of appeal is on the record, it's superseded. So you all need to send the records up. So whatever has to happen
A notice to dismiss that appeal was also filed?
no, I do not believe so.
It's public record, so, would you agree if the notice of appeal was also, are you done with this? If a notice of appeal was also filed, or notice to, or motion to dismiss the appeal was also filed, and that there is no appeal docketed, that the order is in fact not on appeal?
Once a notice of appeal is filed, it's superseded.
Would you agree that your notice of appeal was not filed until after? What's this? We're on or around September 7th. Sorry, that your notice of appeal was filed in September of 2023 after the amended order correcting the individual to pay attorney's fees was entered.
After hearing correct, because there was no evidence of any attorney fees. This was just something that you wrote, that you put in there. So that's the reason why.
Would you agree that this is a court order entered by a judge?
I agree there was a contempt order by you that was denied by the same judge.
I'm talking about this specific order. Isn't it true that the bill of peace was entered into by Judge Alexander?
What date was that bill of peace entered?
The original bill of peace, I can put it on the screen. I'd like this, tender plaintiff's exhibit 11.
P11, you have an extra copy for me? All right, any objection for the record to P11? Mr. Harrison, any objection to P11?
Oh, no objection.
All right, P11 is admitted.
All right, I have P11 up on the screen. Would you agree that this is a court order or a final order on a motion for bill of peace entered into on February 3rd, 2023?
To February 3rd, 2023.
Yes.
Correct.
And I'm not going to go through all of this, but would you agree?
What
that
date was the
this-
court hearing on this?
I show you.
On July 8th, 2022?
Yes. And would you agree that this outlines the various lawsuits that you filed? We call them actions that you filed against the plaintiffs, Miles Carter and Reginald Brown, as well as the current lawsuit we are in court for today.
Yeah, those all seem to be the ones.
And isn't it true that this court order states that you filed a lawsuit against plaintiff Ms. Harrison, alleging identity fraud and theft related to a vehicle of your deceased parents that was purchased for Amari?
That's what it states, but it was conversion for,
Didn't you state already that this is a court order entered into by a judge?
yes.
And isn't it true that this further states that the bill of peace is necessary to prevent future meritless litigation between the parties and to ensure Ms. Amari and Mr. Carter will be able to reside in the property without interference by Mr. Harrison, his family, and or parties he may direct to interfere with Ms. Amari and Mr. Carter's residence at the property?
I agree that's what it states. But at the time that this court orders happened, we had a final order to sell the house. They were no longer supposed to be living there. This bill of peace superseded the court order that we had in place that
Isn't it
stated.
true that the order you're referencing, that the current case we're here for today, that the notice of appeal had already been filed?
Notice of appeal had not been filed by the time we had this court case.
Okay, isn't it true then, sorry, this is.
And as you just stated, that if there's not a notice of appeal if there's not an order of appeal, there is no appeal from what you just stated. So even if when you did file a notice of appeal, the current order should have still stood.
If this order was entered into in February of 2023, which is roughly 4 months prior to the Court of Appeals order overturning the order on motion for summary judgment in this case, then the case we are here for today was actually being reviewed by the Court of Appeals at that time, correct?
But there was not a Court of Appeals opinion at that time.
Isn't it true that you consented, as you stated earlier, to the TRO in the case that we are here for today when it was filed?
The TRO does not state that they can live there. It states that I'm not supposed to remove anything from the property. It doesn't state who's supposed to live there.
There was no order giving you possession of the property, correct?
There was no order restricting my possession of the property. The contract that we have explicitly states that once the final payment is full, I relinquish all rights. I did not relinquish all my rights to the property, which is rights to possession or rights to access. I never relinquished those rights.
Isn't it true that the contract stated that the only parties that were allowed to reside in that property were Miss Amari and Mr. Miles Carter?
No, it states that the only person to reside at the property was Amari Harrison, and Miles Carter can occasionally visit. Does not say he can reside. It says he can occasionally visit.
And you then are not allowed to reside in the property under that contract, correct?
No, I never resided at the property. And neither was my sister. So she's not supposed to reside at the property either.
And that contract did not give you any right of possession, correct?
I did not relinquish any rights. So I have every right of possession because I'm the owner. So I'm on the deed, I'm on the title. I have every right of possession because I'm the owner. And the contract states that I will relinquish all my rights once the contract is paid in full pursuant to the terms.
In December when this contract was entered into, Ms. Harrison paid $30,000 upfront on the installment contract, correct?
Correct.
And all remaining installment payments were paid, correct?
Remaining installment payments were paid, correct.
Now, back to this question. As stated, the court, I'm not going to read it all again, but this order was entered into. The court found and held that a bill of peace as an extreme remedy was necessary to prevent future meritless litigation. Correct?
Correct.
It further states that they are to reside there without interference by you, your family, and or parties that you may direct to interfere with Amari and Miles at the residence, correct?
Correct.
Is it also true that this court order the court found that you have maliciously permitted or caused Michael Harrison, your son, to move into the property to further interfere with Mr. Carter and Ms. Amari's peaceful residence at the property?
I'm really confused how they found that when Michael Harrison was never discussed at the hearing. So I'm really confused how you put that in there 8 months later, but that is what the order states.
We've already established that this is a court order from a judge based on a hearing and evidence presented, correct?
No, we didn't establish that it was based on hearing and evidence. It was as a court order by a judge. That's established.
After a hearing held in July of 2022, correct?
Correct.
And I'm not a judge, correct?
No, you're not a judge, but you did write this order. This was your order that you wrote and sent to the judge 8 months later.
Yes or no, this is a court order entered into by a judge?
Yes.
Thank you. The court also found that you had a history of litigious and vexatious behavior and a willingness to file false pleadings for the purpose of harassing and damaging Mr. Carter, Ms. Amari, and the plaintiff, Ms. Harrison, correct?
That is what it states.
This order further required, or was it ordered and adjudged? The bill of peace was entered, perpetually restraining and enjoining you from litigating or threatening to litigate against Mr. Carter, Ms. Amari, and then the plaintiff, Ms. Harrison. It's rather inclusive as well as to who else this enjoins, correct?
Who else doesn't enjoin?
Based on the language of the court order, it would be you cannot litigate against Mr. Carter, Ms. Amari, Ms. Harrison, their representatives, agents, assigns, or any other person or entity in any forum, any claim or action, and further restrained from interfering or threatening to interfere with the rights of Mr. Carter and Ms. Amari to reside at the property and the property rights of Ms. Harrison as it relates to her interest in the property. And
I think we just established that we still are in a lawsuit over
I'm not asking
the
about
contract.
this lawsuit, Mr.
So I don't
Harrison.
know what rights they had at the
It's a
time.
yes or no question. This is what the court ordered in the bill of peace, correct?
Correct.
I believe you just asked me this, so we can go over it really quickly. The court further enjoined you, your assigns, agents, legal representatives, and any entities which you or your immediate family are connected to and or control, that you are all further restrained and enjoined from filing any lawsuit in this jurisdiction without prior written approval of this court. Correct?
I do see it says immediate family, which Miss Harrison is my immediate family as my sister. So it enjoins her also.
Would you agree that an individual cannot sue themselves?
I don't say anything about suing her. It says she cannot sue anyone.
The order states that you, your assigns, agents, legal representatives, and any entities which you or your or your immediate family
Mhm.
are connected to.
It doesn't say me or my immediate family. She is my immediate family and sister. Immediate family includes siblings.
Would
And
you
it
agree
says
that
any lawsuit in this jurisdiction. It doesn't say against yourself or who.
the bill of peace was entered into to protect Ms. Harrison, Amari, and Miles, correct?
Ms. Harrison wasn't a party to this action, so that's really kind of confusing to
not-
me.
Yes or no? This bill of peace was entered into to protect Ms. Harrison, who you had filed other TPOs or various charges against that were pending at this time. Ms. Amari and Mr. Miles Carter, correct?
It could not have included Ms. Harrison because she was not a party to these actions. This was an action against Amari Harrison and Miles Carter, clearly on the face of the complaint.
I believe we just established, I've just pulled it up for you, that you are perpetually restrained from litigating or threatening against Mr. Carter, Ms. Amari, Ms. Harrison, their representatives, agents, assigns, or any other person or other entity, correct?
Who is Ms. Harrison? Amari is Ms. Harrison.
Ms.
It doesn't say Marilyn Harrison. It says Ms. Harrison. And at the top it calls Amari Harrison. Go to the top of the order.
The individuals with their abbreviations as Miss or Mr., their names are defined in the order.
How can it be defined in the order if she's not part of the case? So it's just,
Defined in the order.
no, it's not, sir. No, it's not. It says Miss Amari, and then it says Miss Harrison. Miss Amari is not, that's not a full name. That's her first name. Her name is Amari Harrison. Please go to the top of what it states. Go back. You see what it says?
Up front. Miles A. Carter, hereinafter Mr. Carter. Marilyn Amari Harrison, hereinafter Miss Amari, correct?
And where does it say Miss Marilyn Harrison here and after Miss
Yes or
Harrison?
No question, I'd appreciate an answer.
Correct.
Marilyn Monique Harrison, hereinafter Miss Harrison, correct?
Correct. It's no, oh, it's correct.
Back to the other question, this order was entered into to protect Miss Amari Harrison, Mr. Miles Carter, and the plaintiff, Mrs. Harrison.
And which case numbers were these for?
This order was entered into to protect Miss Amari, Mr. Carter, and Miss Harrison.
And
correct?
which case numbers were
Yes
this?
or no question?
I'm not sure. I need to know what case numbers these was associated with. And who were the litigants? Who were the litigants in that particular case number?
Question. This bill of peace, restraining and enjoining you, amongst others, was entered into for the protection of Miss Amari Harrison, Mr. Miles Carter, and the plaintiff, Miss Harrison, correct?
Not correct.
The order states that it's entered into for their protection, correct?
For Amari Harrison, Miles Carter. Could you repeat your question?
The order states it is protecting Miss Amari, Mr. Carter, and Miss Harrison from you. I have pulled it up here. You are perpetually restrained and enjoined, litigating or threatening to litigate against Mr. Carter, Miss Amari, Miss Harrison, and so on and so forth, correct?
Correct.
Order further states they are the only parties to reside, only permitted residents of the property, which is in line with the contract. The order further states that Michael Harrison shall not interfere with the property or assets contained in the property. Correct.
Correct.
But isn't it true that personal property was in fact interfered with and removed after the entry of this order?
That's not correct.
Would you agree that, based on the testimony of Ms. Harrison, Mr. Carter, and Ms. Amari Harrison, that when they returned to the property after this bill of peace, that they testified that numerous items of personal property had already been removed and that there had been property damage? I'm asking, would you agree if that was their testimony?
That was their testimony, correct?
So would you agree that if, in fact, your son, Michael Carter, who's also a member of JLMBL Investments, had removed or interfered with removed personal property or interfered with it, that'd be in direct violation of the court order?
I don't agree because Michael Harrison wasn't a party to this action either. I don't see how any court order can enjoin someone that wasn't there to defend themselves.
Isn't it true that you informed the court that your son was moving in the day of the hearing?
I absolutely did not inform the court.
Isn't it true that you informed me that your son was moving in?
I informed you that my son was there preparing the house for sale because we had an order to sell the house, and my son is a real estate agent. He was prepping the house for sale. That's what I informed you.
And isn't it true that he was in fact living in the
After
property?
the court case happened. I informed you of this after the court case happened.
Would you agree then that the contract, which you've already validated, and we've already established the case was up on appeal, the contract provided that only Ms. Amari Harrison and, as you stated, occasionally Mr. Carter were allowed to reside at the property?
Occasionally visit. That's very specific words. Did not say reside. It said he can occasionally visit.
I can pull
Oh, no,
up-
I'm sorry. Occasionally stay the night. Occasionally stay the night. Explicitly what it says.
As opposed to pulling back up, this is already evidence. Sorry, Your Honor, I don't want to ask you to read specifically, but Mr. Harrison, the contract states specifically, purchaser agrees that she may not rent, short-term rent, lease, or allow any other third-party individuals or entities to reside in the aforementioned property except for the current tenant, Marilyn Amari Harrison,
Period.
and, it's not a period, semicolon, and Miles Carter, who occasionally stays overnight until deed is transferred in seller's name only.
I think you just stated the only tenant, which was singular, which is Marilyn Amari Harrison. Then it says, and Miles Carter, who can occasionally stay the night.
It states who occasionally stays the night.
No, it says
Stays
who can.
overnight, correct?
Who can stay. Can I see that, please?
Provide it to you. And isn't it true that your son, Michael Harrison, is not listed in that contract at all, but in fact moved into the property during the pendency of this current litigation?
No, I cannot agree to that.
You do not, isn't it true your son lived in the property you had just testified?
I testified that he moved in after we had a final order. On June 11th, the final order stated to sell the property within 30 days. My son started preparing the house for sale. So although it got overturned in appeal, at that time, there was a final order to sell the house.
Would you agree that there's no final order in this lawsuit since we are here today?
I agree this is going on now, but that doesn't mean there wasn't a final order at that time.
Let me pause you for a moment. Mr. Lidemar, I want to get your position here and your opinion. In that specific section of the contract, I understand it says the purchaser is agreeing that only these certain individuals are going to be the ones who are allowed to reside there. Where here or where else in the contract do you then see the seller's obligation restricting who can stay there or reside?
Based on the testimony of Mr. Harrison, he stated that he didn't have a right to reside there, and neither did Mrs. Harrison. I would say it's the parties.
Maybe that's their feeling now or their impression, but based on the language of this contract, you've been implying that Mr. Harrison wasn't allowed to go there. I don't think he would agree with that, but where is there basically, this shall be the only people who are allowed to reside there? Because that I've not seen or spelled out.
Well, this is an installment contract. I can get into it in closing as opposed to legal argument now, but under an installment contract, he relinquished his possession rights or control of the property as soon as that first installment payment is made.
And is that just a matter of installment contract law, and not necessarily something that's in this contract?
Yes, which this contract would fall under. So he
Okay.
relinquished his equitable interest and his right. And there's nowhere in here where he retains any right of possession of the property.
It says I retain all rights. I will not relinquish any rights until paid in full.
Our
It
position
states
as a
that at the
matter of
bottom.
law, the installment contract.
All right.
is the receipt.
Understood. Okay, you can resume. And just a note, you only have about a little over 10 minutes.
I'm just trying to get through this will go to damages. So this order was entered into, as we established, February of 2023 and gave 48 hours for your son to move out of the property. Isn't that true?
That's what it states.
Isn't it true your son did not, in fact, move out within 48 hours of entry of this order?
My son was not living there at the time the entry was made. My son was not living there. My son was living there while we were supposed to be selling the house. Once you filed your notice of appeal, you all refused to sell. We had an offer on the table for $580,000 and you all refused to sell. You then filed your appeal. There was no reason for him to be there.
I have
And
not
that was
asked you
in July.
about the
Now,
sale.
you specifically asked me, was it true that he was living there at the time this entry was ordered, this order was entered, which was February of 2023. My son was not there and he actually never lived there. He was just there helping to sell the house, get it prepared for sale. In June of 2022, you filed your.
All right, I think you've answered the question. Let's let him ask another question.
I believe we established this from you had previously testified that you agreed that Ms. Harrison, the plaintiff, Ms. Amari Harrison and Mr. Miles Carter all testified that there was, in addition to the January, I believe 20th, 21st of 2021, that when they moved back into the property in February after the entry of this order, that they testified that there was significantly more personal property that had been removed, correct?
Can you repeat your question? I can't see you anymore.
Oh. Previously, you testified and agreed. Do you agree? You testified that Ms. Harrison, the plaintiff, Ms. Amari Harrison, the plaintiff, Mr. Miles Carter testified that in addition to the January of 2021 property removed, that by the time they moved back in after the entry of the bill of peace, that their testimony was that significantly more personal property had been removed from there.
I do recall them testifying that they didn't know who did it because they had no video, they had no evidence of who did it. They testified that there was damage and I guess property missing.
Didn't they also testify that the cameras had been covered with tape?
Yes, they testified to that.
And wouldn't you agree that it'd be very hard to have evidence, video evidence from cameras that were covered with tape?
I absolutely don't agree.
Isn't it true that a camera cannot record anything except for what would be in front of it?
A camera would record someone walking up, damaging the camera, whatever you're saying was happening, or putting tape on the camera.
Would you agree that anything after any items taken or any events happening, the camera might have seen would be unrecordable after tape is placed over there?
I object because this is out of my lack of knowledge. I was not present. I have no idea what could have happened.
That's not my question. Would you agree, if there is tape placed over a camera, that as soon as the tape is over the camera, it cannot record anything that's going on that it might have seen otherwise?
I mean, I guess it depends on what type of tape it is. I'm not sure. That's not my expertise.
Was Mr. Harrison going to direct examine himself as well after this?
I believe so.
This is plaintiff's exhibit 7. These are your combined responses to our discovery requests as well as some supplemental responses. Do you have any objection?
No objection.
Are you tendering P7?
Yes.
P7 submitted without objection.
Thank you. Have on the screen, this is your response to interrogatory number 6. And isn't it true that your verified responses to discovery in this case, that you stated that you had no knowledge of any IRA beneficiary designation form signed by Brenda Romero, which I'm assuming is your mother. And you further state that the only one you saw was from Samantha Hayes, and that was in March of 2021 is when you learned, sorry, March of 2021 is when you learned you were the sole beneficiary.
Yeah, that's when I got the actual that's when I got the actual beneficiary designation form, which is reflected in your exhibit. But if you can go back up, to what the question was, please.
We're on this right now. And we are limited.
But
on time.
you're asking me to respond,
I'm going to ask you something specific about what you stated.
but I can only
It-
think about what I stated based on what you
It's
asked.
a simple statement. The only IRA beneficiary designation form the defendant saw came from Samantha Hayes of Wells Fargo Advisors. Once defendant learned he was the sole beneficiary of the IRA in question. That was in March of 2021.
Correct.
Would you agree that you're stating the first time you learned that you're the sole beneficiary is in March of 2021?
No, I don't agree. I said that's the first time I saw the beneficiary designation form, which was after I learned I was the sole beneficiary form.
But it's been established that you in fact were sent the beneficiary designation form on November 25th.
It's established that I never saw the beneficiary designation form. I testified to that. I did not see it in whatever date that was.
And would you agree that if it's presumed to have, or if it is sent, it's presumed to have been received via email?
I don't know if the legal standard of that. I just know I didn't see it.
All right, Your Honor, I know I'm out of time.
All right, thank you. We'll leave it there.
Yes.
If I'm gonna have to take a personal point of privilege here. We'll do a 5-minute recess, hold in place. Feel free to use the restroom if you need to. We'll be
Okay.
back, Mr. Harrison. I think we'll have you stay on the stand and you can give a narrative of any testimony that you would like to have
Okay.
introduced in this case for your case in chief, for any, your counterclaims or anything else you feel relevant. Again, the guardrails will be, I'm going to reserve the ability to jump in if I feel we're getting too far astray.
Okay.
And Mr. Lademeyer is always going to have the ability to object if he feels we're going into inappropriate matters. All right? Any
And-
questions for me?
Yes, please. Would I be able to have my laptop up here so I
That's
can
fine. I
stream
think that
it?
would be fine. I would say, however, though, that whenever a witness testifies, they're not supposed to be reading off something. And so if you're looking at your notes or referring to your laptop, I think you need to note that for the record, and you shouldn't be reading it. So you can refer to something, but then you got to put that thing down and resume your testimony.
No, I was speaking of having my laptop so I can show evidence. Stream.
Oh,
from-
certainly, if it's for exhibits, you can then tender those,
Okay.
show them, do whatever else you need to do.
Okay.
But we've got to make sure there's that distinction where you're not just looking at notes or reading off something. Okay.
Yes, sir. Yes,
Any
Your
other
Honor.
questions for me?
No, Your Honor.
All right, let's come back in 5 minutes.
Thank you, Your Honor.
I don't think I see you on the Zoom meeting yet. Do you want to make sure you're in?
It was a separate link sent this morning.
That way we're ready to go.
Okay. Well, Excuse me, sir. Excuse me. Is there a plug on this side over here?
I'm sorry.
Is there a plug over here? Oh, I see it. There. It's not a closer plug, is it?
What you trying to plug up?
My laptop, just so I can. It might stretch on. You don't mind me stretching that, do you?
I guess, I guess it'd be all right though. Nobody trip on you.
All right.
For years.
Come to order.
All right, let's go back on the record. Mr. Harrison. Floor is yours.
Okay. I was just trying to, I couldn't get in on this. She wanted me to get on the Zoom. All right.
Saying you need to be admitted to the Zoom link or?
Yes, sir.
Okay.
I'm just getting hooked up into it.
All right, we should have you added and as a co-host as well.
Okay. My name is James Carl Harrison Jr. I am the brother of the plaintiff and the uncle of the plaintiff. I'm here for a breach of contract clause that my sister and I entered into. It's a valid buy-sell agreement where Ms. Harrison approached me to purchase my half of a house that we own. She has breached that contract. So I'd just like to start off giving you a narrative of the events that led up to this particular day. My mother died on November 3rd, 2020. My father died about 8 months earlier on February 24th, 2020. After my father died, I believe everybody was distraught, but at the same time, it was something that didn't happen very quickly. My father was in the hospital. He had been hospitalized. He had been going in and out the hospital for some years, but in around October, he went into the hospital, and then he just never came back because he was going in and he was having physical therapy that had to be done. That physical therapy turned into a stroke that he had, and it just ended up that he stayed and he had to get sent to an LTAC, and from that point he just went downhill. We were not prepared for it. We actually thought he would have been coming home, but he didn't come home. When he died, my sister, my wife, my nephew and niece, and the whole family, it's not much of us, but we were all there. We consoled each other. And we instantly started getting into, I guess, post-grievance mode. At the time that my father died, we had just gone through a series of relatives that had passed away from aunts. Our grandmother just passed away in 2019. It was just a lot of death going on in the family. When my dad died, 2 or 3 weeks later, COVID took over. And so it put us in a situation where my mother wasn't really, she was retired and she did not pay the bills. So she didn't know what bills to pay. She didn't know any of that. So while my father was in the hospital, I was helping her pay the bills. I was helping her manage a lot of the finances from that perspective. But prior to my father going to the hospital, my father, as I said, he had been sick and ill. He specifically had me handling certain things, specifically the taxes. Um, when he, that was my first interaction, maybe a couple years earlier, with him having an IRA, which is something that I never knew that existed. It's not something that they ever spoke to us about, was at least not spoke to me about. But I did know that he had to appoint for the taxes. He had a mandatory distribution every year that he had to make. So I know that had to be something that was a statement that came. That's all I ever saw was a statement, and that was included in the taxes. So I knew from that perspective that there was an IRA. Once my father passed away, I took advice from some uncles. As I stated, my grandmother had just passed. So I had uncles who were kind of guiding me through the process of everything that needed to be done. One of those things in particular, was making sure you closed a lot of bank accounts. They told me to make sure you contact Social Security, and it was just all the different house cleaning stuff you had to do when someone passes away. Because I had been paying the bills, I knew which insurance policies that they had premiums that they were paying premiums on. So, me and my mother sat down. My sister was invited. Sometimes she sat down with us, but a lot of times she didn't come because she was really grieving also. And so she didn't really come around. She came around occasionally. I do recall one time when she came, she sat down with us to go through bills because we was trying to figure out, we didn't know where anything was. We didn't know where the wills were. We didn't know, like my father was what you call a pack rat. Nothing was organized. So we were trying to organize everything that had to be done. And we did come up with an organization system. My sister came over and helped for a little while. She then had friends that came over and they sat back and I guess they were consoling her. They were drinking wine and stuff like that. Me and my mother continued to finish doing what we were doing. We came up with an organizational system. Because everything was in disarray, my father was a pack rat. There were insurance policies. There was basically insurance policies that expanded over probably 10 or 20 years, 30 years, maybe 40 years from some of his very first policies that were connected. But it was a lot of stuff that was together, but a lot of it was irrelevant at the time because insurance companies buy out policies. So for example, he had an Atlanta life insurance policy that had been bought out by another insurance company that was bought out by another insurance company. And so although he had records for all of this, we had to put them together. So over the next few weeks, me and my mother sat down. I was calling these places. I was figuring out, connecting all the dots, figuring out what was what. And we came up with an organizational system to put together Atlanta Life and the other company and put those together that this was all the same policy. And that's how we found out about the IRA. Because at that point in time, there was multiple packages of coming from that looked like IRA papers. One might have had Wells Fargo on it. Some of it had Wachovia on it. Another thing had Brightstar. And it took us a while to figure out they were all the same thing. Put all those together. My mother contacted them, but she would have either me or my sister actually talk because she was kind of hard of hearing. She would have one of us talk to them. We did talk to them. She was able to get his processed. But like I said, at the time, we had no idea what was what. All we did was contact them. They let us know that you have to send a death certificate. It was just pretty much a notice. You let this person know they're deceased. And so I was kind of familiar with that because we had to do the same thing with the funeral home. We had to do the same thing with insurance and banks. We contacted them, let them know that my father had passed away. And from that point on, things started coming in to my mother. And once those things came in, they started getting processed, however she processed them. Like I said, me, my sister, and myself sat around and helped with that. I just can't remember all the details. But at that particular time, COVID was just kicking in. So a lot of things was really, really, really delayed. I do recall them being the one big insurance policy that we thought my dad had. And when I was paying the bills, it was one bill, that I knew of that I thought was going to be a big policy for my mother to be able to live on. And to come to find out it was an accidental death policy. And so that one didn't apply. So I remember we were trying to figure out, even though my mother made the bulk of the money at that time, there were not a lot of insurance policies that were left in place to cover her. And it was confusing because my father was an insurance executive. He was an actuary, but he did not have insurance policies. And I only believe it was because, he feels like insurance is one of those type of things that, you pay.
All right, Mr. Harrison, I want to direct you back towards kind of the issues in contention here today. I don't see the entire winding up of the estate being what we're talking about mostly in this
okay,
trial.
okay.
It's more, the IRA, how you and your sister handled the estate maybe.
Okay.
And your reactions there. That seems more relevant to me. I'm not seeing
Okay.
these other issues being relevant.
Okay. Well, like I stated, when my mother died in November. So when she died in November, she was, of course, she inherited a lot of stuff. Whatever was in the estate was inherited by her. We could not find the wills at the time. My mother told us earlier that they had been, they was down at probate, but she didn't have any copies of the will. When my mother died, it really caught me off guard because she had a fall. After my father passed away, she started to kind of go downhill. She had a fall, she had an accident, and from that point on, she just never got better. She went in and out the hospital multiple times, but on this particular, this is the fourth time that she went. She never came back. It was only me up there. My sister and all her family was out of town, so I actually witnessed her die. I actually witnessed the excrements come out of her at the time.
Section, relevance on this, I believe we were talking about the estate.
I'm just speaking on the relationship with me and my mother. We were very close.
All right,
which
so
is
overruled, but we're, with a limited basis, we need to keep moving, okay?
okay. So I was really close with my mother. So once I saw her passed away, that's the feelings that I had. Why I did not like going over to that house anymore. The reason why I did not like going to that house is because I saw her deteriorate in that house, where she couldn't even sleep in her bed anymore. She couldn't even go to the restroom. She had to be on a potty. I did not like going to the house, which is why I wanted to sell the house. So after my mother passed away, I started the same program with my mother, contacting the insurance that I knew of. And things were already organized at that time, so it was much easier, faster. I started contacting everything. My sister could have been there, but as she stated, this is not something she's testified, I think, that she was very distraught at the time and she was kind of checked out. And I took over that role as the big brother. She could have been involved in everything, but I kept her up to date on everything that happened along the way. Any insurance place that I contacted, I would let her know I contacted them. I would let them know. I would let her know that if they call me, I would tell her about it. If they sent something in the mail, I would tell her about it. When it came to the IRA, on this particular date, I specifically told her what date that it was probably around November the 19th when Samantha Hayes contacted me. She contacted me via on the telephone. She verified my date of birth, my social security number. She told me I was a beneficiary. She began to ask me if I wanted to, the first thing she asked me was that I want to keep or disclaim the assets. I told her I wanted to keep them, or the benefits. I told her I wanted to keep them, and she then told me that, okay, she asked me all the different things over the phone, which was specifically, how did I want to receive the benefits? Was it going to be a lump sum, a rollover, or would it be, would they open up an IRA for me? Well, I chose for them to open up an IRA at Wells Fargo for me because I was currently banking with Wells Fargo. I thought it would just be an easier transition. She opened up an account, I guess, over the phone. Maybe the next day she sent me over a package which included the IRA forms to open for me to sign, which my new IRA. She then sent over the beneficiary claim form. She then sent over an affidavit of domicile. Those are the three things that she sent to me. Once she sent those to me, they was already pre-filled, and I have personal knowledge of these because I signed them. So I would like to introduce the beneficiary claim form.
Aren't those already, are the record as part of plaintiff's exhibits?
Yes, they are actually.
I
The
would like to
unsigned and signed versions, I believe, are already a record.
Okay, so what I think you're asking to introduce and tender is already part of the record.
Okay, so I can just refer to it. Can I run and get it real quick? I actually left it. Okay.
Do you happen to know offhand which plaintiff's exhibit this would be, Mr. Ledemar?
That would be plaintiff's exhibit 2.
All right.
Okay, so I'd like to refer to plaintiff's exhibit 2. Would you like a copy just to look at?
I've got one.
Okay.
I just want to make sure that that is the same. Trying to find the one he signed. And this is the beneficiary claim form or the affidavit of domicile?
The beneficiary claim form. Okay, on the beneficiary claim form,
Wait, I wanted to see if that's the same. I don't know if I have a signed copy.
All right, what are we waiting on?
I don't know if there is a signed copy of the beneficiary claim form. I know that there is a signed copy of the affidavit of domicile.
All right, so if
I
it's
have
not, if it's not included in P2,
It
Mr.
is.
Harrison, if you've got another copy here of what you're trying to introduce, I don't recall exactly what defense exhibit we're on.
Your Honor, it is page 44 of plaintiff's exhibit P2.
Okay, all right, so strike that or disregard that rather, and you can continue, Mr. Harrison.
okay, so this is the IRA beneficiary claim form that I filled out. I would like to just point out the very first paragraph. It states to claim the assets from a decedent's IRA. This form needs to be completed by the beneficiary. A separate form is required for each beneficiary. Okay, so when I received this form, I was under the impression that my sister and I were joint beneficiaries. Further, it goes on to state, as you see down in section 2, as the name of the individual, which is James C. Harrison, as my social, which is redacted. But the original relationship to account holder is non-spouse. Okay, so this is what was already pre-filled out to me and sent to me. When you go over to page 3, or up top, it says page 7 of 10, but it's section 5. Section 5 is where, like I said, she asked me, how do you want to get this? You want to get it as a rollover? You want to get it as an inherited or a lump sum? In the second section is checked for inherited IRA. It says, please select your beneficiary category from one of the 3 below. In bold, it says, if you do not select one of the options, we cannot assist you at this time. Let me see. Okay, designated beneficiary is a non-spouse individual. So this is the form that I received. Even though it's only filled out by me, it's only signed by me. I took this to be a form that was for one or multiple beneficiaries based on the language on the form, and that it was just for individual options. So if someone was a sole beneficiary, I definitely said, okay, this is what someone would get. But if there was multiple beneficiaries, everyone would get the same thing. They also sent an affidavit of domicile. Is that on the record also?
Yes, it is.
Which exhibit would that be?
Plaintiff's Exhibit 1.
On this affidavit of domicile, again, it says James C. Harrison, I am the beneficiary. Up under that, you can see you have, it's already pre-filled in, but it states that you either are the executor, the administrator, the personal rep, beneficiary, trustee, or survivor. This was signed and dated on November 21st and notarized. However, it's simply certifying that Ms. Harrison lived there in Georgia for 50 years. I think it's already on the record that when they originally sent this to me, they had an issue where instead of the state of Georgia, it said the state of Alabama. They made a slight mistake. I corrected it. But both of these forms, at no point in time did it certify that I'm the sole beneficiary. It shows that I'm a beneficiary. She also sent me over the forms for me to fill out my specific IRA. I had to sign that. I had to assign beneficiaries of my own. At that point in time, I knew primary beneficiaries, you can have more than one. I knew secondary beneficiaries. After I received these forms, I sent my sister a text message, told her, well, actually, after I received the phone call from Samantha Hayes, I texted her and told her to look out for a 205 area code, because when they called me, I answered my phone, but it did not say Wells Fargo. It was a 205 area code. I text my sister, told her to be on the lookout for a 205 area code because she doesn't traditionally answer her phone. So if she didn't recognize it, I didn't think she was going to answer, and I didn't want her to miss the call. A few days later, after I had the forms, I think I may have been on the way to get them notarized, or maybe they was already notarized. I can't remember, but my sister and I discussed meeting up. I met up with her at her boyfriend's house, Reggie. That's where at her house, that's where she lives. I met her there because I told her I did not at the time like going to the home house. We call it the home house. Everyone in the family had a key to this house. I did not like going to the home house because I still felt my mother's presence there, and it was sad to me. I was trying to stay strong for the family as the older brother. I just didn't want to go there. I met her at her house. We were meeting up to start talking about dividing property. I didn't refer to it as property of the estate because I didn't look at it like an estate. We just looked at it as my parents' stuff. I told her specifically I didn't want anything except some keepsakes for me I didn't want TVs and all that kind of stuff. All I wanted was some pictures and art, which is what was sentimental to me, and some paraphernalia, things of that nature. She told me, okay, fine. She told me, whatever pictures you get, just make sure you make a copy and then you give them back to me. All the art that I got was pictures. I got 2 pictures or art. I got 2 pictures of art, and I got some family pictures that were all hanging on the wall. This is what we discussed. But at that time, I talked to her about it. She agreed. We sat around. We had a couple drinks. She told me that, I never got a phone call from the Wells Fargo. And I sit back and said, I said, you didn't? She said, no, but I tried to call them and they wouldn't talk to me because they had some kind of issue between primary and secondary beneficiary. She said, but I'll get it worked out. I sat back and told her, I said, oh, well, I can give you the number to the lady who called me specifically instead of you just calling the number. I then text her the number for Samantha Hayes, which was testified to yesterday. Mr. Lettermeyer pointed to that part of the text messages between us. I texted her the phone number for Samantha Hayes. At that point in time, we never spoke about it again. It wasn't something that we were not in discussions about the house. We were not in discussions about anything specific, except we were just being siblings at that time. So this was probably the first insurance or financial instrument that contacted. From that point on, we started getting calls or email or texts, or not, started getting calls or mails from different insurance companies that I'd already submitted. If I got anything, I would call her, I would tell her about it, I would text her. We wasn't talking a whole lot because she didn't answer all the time, but I would text. But if I called and she answered, we would talk. But on that particular date, we just sat around and we just talked. We didn't talk anything else about the IRA. There was no discussions about her buying the house. It was simply us just being siblings. This was shortly before Thanksgiving, so I sit back and said, I want to have Thanksgiving dinner at my house. And I invited all of them to come over, and because I just didn't want to do it over at their house. I made that clear to her. I just didn't like going over there anymore. They all came over on Thanksgiving. We never discussed the IRA anymore. But shortly after that, we did discuss dividing the property. We did end up meeting at the house, the home house, and we discussed dividing the vehicles. There were 4 vehicles. There was a Jaguar, a Lexus, a Mitsubishi, and a Nissan. We discussed dividing those vehicles. Her son had a car that he wanted to get another car. So she discussed taking some of the cars and trading them in. I agreed with it, but we were supposed to divide the other 2 cars, but they were all left at the home house. I never saw a distinction. At this particular time, we weren't selling the house, we weren't selling the property. Everything was still at the house. Everything just remained the same. So I met with her son. He kept texting me, kept calling me, asking me, when can I meet? Can you come out here? And then that didn't fall through, that fell through. Then he would come back and say another one. And finally I told him, well, I'm not going to meet you. Just whenever you find something, you just let me know, then I'll come and I'll fill out the paperwork, because I had all the titles to the car in the safe that my mother had wanted me to keep together. All the financial stuff, like the titles to the car, the insurance, things like that, was all in a safe that was at the house. And the one that had the titles to the car, I had the titles, but I didn't have the keys. The keys were still at the house. So we would meet at the house for him to get the keys. I met him out there with the titles and the keys. I helped him facilitate trading in those cars. He traded in the cars for, I think it was $7,800 or $8,000, somewhere close to that, in order for him to trade it in for, I think he got a Kia, I think at the time, a 2020 Kia. It was titled in her boyfriend's name, Reginald. I remember texting. I had a text conversation with Miles. That text conversation, we discussed that I told him I was proud of him. I asked him, did he use his credit? Like, I just said, I thought that at 18 or 19 that he was making a big move putting in his name, but he said that he didn't put in his name. He didn't know nothing about credit, and that Brown had done it. So I said, okay, I'm still proud of you. Everything was good. From that point on, this was maybe December the 5th or 6th. I had just my sister's birthday. My sister's birthday was December the 4th. I invited all of them out. I was going to take them all out for brunch for her birthday. I met with her. Miles didn't come, but Amari. So I picked up her and Amari. We all went to eat. But at this point in time, we had already started talking about selling the home to a third party. That third party his name was Collis Clovey. And we all knew Collis Clovey because he's the one that sold an aunt's house who had just passed previously. She passed earlier, either late 19 or earlier 2020. I can't remember exactly. But she had already quit claimed her house to my dad. I'm not sure when, but it was already previously quit claimed into his name. And then once he passed away, it passed on to my mom. I think it might have been quit claiming in both of their names. I can't remember, but my mom ended up with it. And this was still during COVID. It was nothing that we wanted to do, she wanted to do with it. So, you know, we got some kind of lead for someone who could buy the house quick without having to go through all the necessary things of fixing it up and all that kind of stuff. So we got introduced to Collis Clovey. Once we met Collis Clovey doing that transaction, he primarily dealt with my sister because she was into flipping houses. So she was the one that dealt with Collis Clovey. She specifically, matter of fact, after we did the deal, it was specific that no contents could have been left in that house. He was going to charge a penalty if anything was left in the house.
Based
It's
on-
hearsay, but it's also.
This is
I guess
what
they
he.
can object
Well,
on
I'm
the
just-
hearsays
All right, hearsay as to what this
as to the
individual.
contents of the property. If his conversation is with this Clovey regarding a sale and contents, it's hearsay.
All right, any response to an objection
I
based
was.
on hearsay?
This is what he told me. It's not hearsay.
Well, I think that would be the definition of hearsay. So let's stick to, unless there's some other non-hearsay purpose, you've got it.
Okay.
You stick to your things within your personal knowledge, all right?
Okay. So, well, for whatever reason, my sister had to go over there and clean everything out the house. Yeah, all the way down to some carpet that was just left, like a roll of carpet. It all had to be gone, and she made sure she got rid of that. Once we started talking about selling the house, I told my sister that I just didn't want to. I wanted to sell the house. I wanted to come off the deed. Primarily, I wanted to come off the deed because I knew that her daughter was currently living there, and her son was coming back and forth. I just didn't want to be responsible with my name on the title because my mother had already quit claimed the house to us. With my name being on the title, I didn't want to be responsible for anything going on at the house. She quit claimed the house to us some months before she passed. And so at this particular time, I knew that if anything happened at the house, you know, we would all be held responsible. And I didn't want me or my family to be held responsible for something that I had nothing to do with. So, you know, I didn't necessarily convey that to my sister, but I also knew that it was a lot of upkeep for that house, and I was already upkeeping my house. And it's just something that I didn't want to continue to do, especially with the taxes and all that kind of stuff. I know homestead exemption would not apply anymore because we were not living there. So it was a number of reasons why I wanted to go ahead and sell the house. So we started talking to Clovey about selling the house. He first of all, he gave you know, an offer of like 230, and then he came back to 260. He eventually told me that he would have went up to 300.
Objection, hearsay.
Okay, he would have eventually went up to 300.
All right, noted for the record, I'll give it the weight it's due. Please continue, Mr. Harrison.
Okay. At that particular time, I let my sister know about the offer. She didn't like the offer. And I told her I know it's low because I know that the house is worth more. But I said we don't have to fix it. I knew it was stuff that needed to be repaired at the home. It's not something that we would have had to do. So if we sell it and it's a cash offer, we'll both be able to split money and walk away. And then you can buy whatever you want to buy. I could buy whatever I want to buy, however you want to do with your half. She said that she was going to go out and find a better offer because That was the field that she was in. She said she had some contacts. She was going to go out and find a better offer. And from that point on, I said, okay. She just never came back to me with a better offer. And I think she did testify yesterday that she was just stalling because she really wanted to get her finances together to buy it. But this is not something that she ever conveyed to me.
Objection, that's completely contrary to the evidence before the court. There was no
That's-
testimony as to stalling.
All right, that's not a valid objection. Overruled.
Okay, so she so I didn't know that at the time. I just knew that I felt that she was stalling because she just never came back to me with an offer. So I kind of got angsty about it because I'm like letting her know we have an offer on the table. And so finally, after I took out for her lunch, for her brunch, when we came back to the house, because we all rode in the same car, right before she was about to leave, I brought it up again. I said, Monique, what's going on with that offer? Have you heard anything back? She said, I did find a better offer, but I'm gonna let you know about it when I come. When I call you, I'll let you know about it. I'm still waiting on another offer to come through, and I'm gonna weigh the options, and then I'll let you know. So when we started our conversations on the 8th, I'm asking her, had you heard anything yet? I'm texting her. She says, I did hear something, and I'll let you know when I come over. She wanted to come by the house in person to tell me. So I just assume, I'm like, why can't you just tell me now? She said, I'll tell you, when I get there. So she came to the house, but instead of telling me about another offer, she told me about her offer. Her offer was to buy my half of the house. And she had tears in her eyes because she was just telling me how she just really wanted to keep the house for herself. And, instead of being a better offer, it was the exact same offer. It was just at much different terms. Instead of being Clovey's offer was a cash offer, which he was going to no closing costs, no repairs. We would have closed and we would have had cash within 24 hours wired to our account. Her offer was that she wanted to pay, at the time, her initial offer was I think it was $20,000 up front. Then she wanted to relinquish me her interest in the IRA that she valued at $77,000. Then she wanted to pay a lump sum payment at the end of $30,000. I believe that's what it was. It would have totaled $130. So maybe I'm a little off on those numbers. But I do know for sure that she valued the IRA at $77,000 and that she valued the deposit was going to be $30,000. So I think it may have been $27,000 is what she said she wanted to give me up front. I sit back and say, I told her, well, why you didn't just tell me you wanted to buy the house? This wasn't like a big thing, because I wasn't doing it for the money. I knew that the house was worth more, but I just wanted to come off the deed. But I'm just not going to give the house away. I just wanted to come off the deed. So I told her that you could have just told me that a long time ago. You didn't have to wait 2 or 3 weeks and keep giving me the runaround for you to do that. And then she had a sigh of relief that I was amenable to the offer. And I sit back and said, but you do realize that, there's taxes got to be paid on IRA. Like this is not just cash money sitting in the bank. So whatever money is in the account, which she had told me based on because her kids was living at the house, the mail that was coming in at the house, which is where everything came, she said there was 2 difference. One would have been 155 and one would have been 133. And, when she showed that to me, I wasn't really sure as to exactly how any of that worked. So, I wasn't sure about the annuity part and I just didn't know. So I told her, you're saying 77, you're just automatically assuming that it's at the higher price. It could be at the lower price, but even so, like your total amount is equaling 130. But if I got to pay taxes on it, it's going to be less than 130, which is what I get. She told me at the time that that she understood that. Then I asked her, well, have you spoken back to Wells Fargo? And she told me, yeah, I spoke to them. And she told me at that point in time that yes, they had gotten everything straightened out. She told me that she had filled out her beneficiary claim form. She told me that, and she had filled out some kind of form to disclaim the interest. I do recall that being part of this beneficiary claim form, but I didn't really pay too much attention to it because it's not something that I agreed to. I wasn't going to disclaim my interest, so I wasn't familiar with the form. But she told me she had already spoken to them and got it set up where she can transfer her interest to me, so I would get the whole thing. And I said, well, okay, cool. So I told her, and why don't you send me that, because she had her contract was on her phone. She didn't come with any paper contract. She came to it with me on her phone, and she was showing it to me in her phone. And so I said, well, send me a copy of that so I can look it over. Later that day, I reached back out to Samantha Hayes via email. When I reached out to her via email, she specifically, and I was asking her about the taxes interest, which we discussed yesterday. She initially told me, it's going to be 10%. And, and she told me that the taxes is going to be based on your tax bracket. She also, I had also been advised, I'm not sure if she told me in that email or not, but she had also told me that I think on the paperwork, it states that you have to have everything taken out within 10 years because that's the difference between a spouse IRA and a non-spouse IRA. The spouse IRA, you can last for your lifetime. So you would have minimal distributions, whereas if you were non-spouse, everything had to come out within 10 years. So, I responded back to her with the text, telling her about that. Like, if you're gonna transfer your interest to me, I'm gonna have to pay taxes on it, but I can't just let it last forever. I'm gonna have to take it out. And whenever I take it out, I'm gonna have to pay taxes on it. So we started discussions from that point. We started going back and forth with different, versions of the contract. At this point in time, I did not know I was the sole beneficiary. Yes, I did reach out. Once I was informed I was a beneficiary, I did exchange some emails back and forth, with Wells Fargo. Now, this has been 4 years ago, so I definitely couldn't recall all the different conversations that we had, but they were, pretty much minimal conversations, but it was something that I just didn't recall. At one point in time, I did reach out because after my sister told me that there were some issues between the primary and secondary, we never spoke about it again, but I do recall reaching out to Samantha Hayes to get clarification on the primary beneficiary, secondary beneficiary, or whatever. She sent me an email. There was a secured email. I looked at it through my phone. From her answer, all she stated was that, as she told me that you are the primary beneficiary, as you see, and there's no contingent beneficiaries. Well, she answered my question, but at that particular time, we were not in any discussions about the contract. So by the time she came to me with this particular contract, I asked her, had she got everything straightened out? She told me she did. I took her for her word. I did not know I was sole beneficiary. I had never told her that it was a mistake. We never even talked about it being a mistake at this particular time. Ms. Harrison always represented that she was a joint beneficiary and she was going to be able to transfer her interest to me. We went back and forth several times. Negotiations, I guess, lasted maybe 10 days. I would like to submit Exhibit D3 for the record.
I think we had a D3 already noted for the record.
I thought it came off. I thought
It did, but we still want to refer to that
Refer
by
to
the
that,
same
okay.
number. So we've already had a D3, we've already had a D4, so this would be D5. What are you tendering as D5?
okay, this would be the text conversation. I think I left her.
You need to show it to opposing counsel as well.
Yeah.
Is this something that was not already admitted as part of his exhibit?
Not sure, because he did, I saw everything on video.
All right, well, why don't you show it to him? We'll see. Again, we're just trying to avoid duplication here.
I know you had a long video, I couldn't, you were scrolling through everything pretty fast.
Yeah, the video was, I believe, everything. So these started December 14th. Is this the same as that?
Yeah, these are the same. I'm just starting these from the date of the conversation that I want to refer to.
Okay, I think these are all of record as plaintiff's exhibit 10. Yeah, these are all part of plaintiff's exhibit 10.
All right, in that case, Mr. Harrison, you can refer to them just if it's easier for you to
Promise.
refer to them on the stand, but these have already been admitted and as plaintiff's exhibit 10.
I think he would have given you a whole lot of them, but you want to just get the.
I've got them here as well. Like I'll just refer to my original exhibit.
Okay, so there's not really page numbers on it, so I can refer to the dates. Would that be? Okay. Okay, so this starts on December 14th. As I stated, Ms. Harrison had been, in my opinion, stalling from the beginning with the negotiations with the Clovey. So at this particular time, I felt that she was stalling again because she specifically told me the terms that she wanted. And I thought I was giving her the exact terms that she wanted, but she just kept going back and forth, back and forth. And so I'm going to read some of these, but I definitely won't read the curse words because this is just.
Well, again, I've been trying to avoid just reading something I can
Okay.
already refer to. So why don't you give me what else you want me to know other than what's already reflected in these texts?
Okay, well, I wanted to show that I'm telling her that these are the terms that we agreed to. It's plain English, not legalese. I'm telling her that you don't have to make this obligation. She wanted to buy the house. I was not pressuring her into trying to buy this house. I'm clearly telling her you don't have to make that obligation because we can always sell to the wholesaler. It will be better for us both. Okay, but if you want the house, then you got to get off the fence. This wasn't something I was trying to pressure her to do, but I definitely wanted to come off the house. I said, I know it's a huge financial obligation for you. She told me how she knows and she accepts the responsibility. She's not on the fence. You know, so she had to go again. We went back and forth about some things that were being sent through the email. I want to clarify with her that I only got a lawyer to draft the agreement because her numbers were wrong. The reason why I stated that is because what she initially sent was really confusing. Like I didn't understand it and I didn't want to get caught up in something that I didn't understand because it made it sound like payments would have been made that wasn't made. And I didn't know if she was actually trying to do that on purpose or it was just a like it was just the way it was written wrong. I had someone to redraw the agreement, which is a version of the agreement that we have. So Ms. Harrison came to me with an agreement in her phone on text, but I got it put into like a format that looks like a real contract. I'm telling her, just remember this deal is for you. It was your idea. It's what you want. So if it's truly what you want and you just need more time with the quarterly payments, just say so, but stop stalling. And she's trying to tell me she's not stalling. I'm telling her it's already not fair for me that I'm working with you And if you want to keep the house, you know what I'm saying, how much fairer can it be? You know, and I started going on telling her about, you know, essentially she's only paying 23% up front. And then the 45% is going to be paid over 9 to 12 months because she's doing it in installments. And then I'm telling her that the rest is going to be paid, you know, over 10 years because she was supposed to relinquish her IRA to me. And so if she relinquished her IRA to me, I'm not explicitly tied. However, me and my family chose to do with the IRA would have nothing to do with her. So I'm looking at like, if I chose to take it out over 10 years, I should have that option. If I want to take it out in 1 year, I should have that option. But at the end of the day, I still expect it to net $130,000. You know, and if it's going to take 10 years for me to get all my money, then it's not fair for me if you are getting everything right now. She said she spoke to a lawyer. The numbers are good, this, that, and the other. I think we did go over this yesterday about the different points. I'm telling her that, you know, some things that she cut out, and the thing that really specifically that I really had a problem with was that she removed the part about the deposit and the $130,000 coming back to me in the default clause because we was discussing the default clause. Was going back and forth, and I'm letting her know. She's trying to tell me that why would that not come back to me if God forbid something happened and I can't finish paying and we do end up selling the house? Why would I pay you $30,000? How is that fair? And I'm telling her, is you're not paying me $30,000. It's just being applied to my share of the $130,000. I mean, so I'm making it clear that I expect it to net $130,000. She said maybe I'm confused. You know, I'm going on to just let her know that this is a deal that she really wanted, that we could have sold to Clovey, and instead I'm doing your deal. So me trying to take half of our IRA was never my intention. We could have sold to Clovey, which would have had nothing to do with an IRA. So I'm trying to make that clear to her, to let her know that this is a deal that's going to benefit you more than it benefits me. But I'm trying to work with you. Like the whole thing is your terms. The only thing I add which protects me is the clause, and that's is what you want to take out. And that's what we started going back and forth with. I tell her it's only a penalty if you can't make the payments and if the offers on the house are lower than what's on the table now. But specifically, I sit back and tell her, I'm trying to work with you. I tell her, then let's take the IRA off the table. Make it an all cash offer like Clovey. And then we just split the IRA over 10 years like we would have done in the first place. Then I said, sit back and made sure she understand how this is working with you. Like you're the one that wants to use the IRA. I'm not trying to ask you to use the IRA. Then she told me that wasn't her original plan. She told me from the beginning that she wanted to get all the money out immediately. You know, and so going back to the beneficiary claim form, these particular forms, everyone has their own individual options. My option was to put it into another IRA. She told me earlier she wanted to take it all out in a lump sum. Well, that was in line with me, with her telling me she filled out her own form. I felt like this is exactly what she planned on doing. But what she did let me know was that she did not want to wait 10 years. And what we also had discussed was I think it took about 4 or 5 months, maybe about 4 months for my father's IRA. I guess she didn't want to wait that long either. She wanted to go ahead and get access to it right now. And she wanted to make a deal for it right now. So I sit back and told you that 260 was the best I found. You were supposed to be finding a better deal. So if you found better and instead of sharing it with me, you want to buy me out so you can make more, then so be it. That speaks volumes. I said, but nothing is guaranteed. There's a new administration taking office in January that affects the market, which affects the industry. Real estate goes up and down, but if Amari and Miles flood the basement again It's definitely not going to be worth what it's right now. The reason why I text that was because this house has had the basement renovated on 4 separate occasions. And on each occasion, it was because the kids are over there. This is on a septic tank. The kids are over there and they are putting paper towels and they are putting trash and everything in the toilets.
Objection, Your Honor, speculation.
I think he can testify as to his opinions, which are partly based on his own interactions and visits to the house. So I think that goes to their weight, not admissibility. Mr. Harrison, overruled. You can continue.
Because the kids were constantly putting paper towels and they just didn't understand that you couldn't put that, which a lot of kids wouldn't, a lot of adults don't. But it was a continual thing. And the basement would flood to the point where there would be septic tank water all over the basement, which would require a complete total basement renovation. In fact, my father never saw the final basement renovation because the same thing had just happened prior to him dying. My sister facilitated getting the basement renovated because she said that's what she does. And so it took about a year, 9 months to a year to complete. My father never came home and saw the completed basement finished. So going into this whole sales situation, this is all on my mind, that we have a house over here that's 50 years old that has a lot of renovations that need to be done. And there are kids living over here that I didn't want to have to pay for another basement. So I wanted to come off the deed, which is what I was telling her. I said I wanted to come off the deed one way or the other. So whether if you're not gonna buy me out, then we can always sell to Clovey. And I told her she said, well, you can't sell to Clovey without me. And I told her that's definitely not true because I do understand that there's something called a partition. But I wasn't trying to go to court. I don't take people to court. This is all happening because of this situation. Every situation that I've had with her or her daughter or her son was all over this house. It's not something that I've ever done before. So I wasn't trying to go to partition. If she wanted to buy, we just worked the deal out. So at that time, on December 17th, we finally met and executed. During the negotiations, at no point in time did we ever discuss contents of the house. Never. We only discussed the house. Everything in the contract is about the house. It even states that I'm going to relinquish my interest in the house. I'll sign the deed over. The title of the contract is a buy-sale agreement between co-owners of real property. The merger clause states that the parties expressly agree that this is a real estate contract. Now, I do understand that contents were put in there. And so it's nothing I can do about that. But the intent of the parties was never, because it was never discussed, was to sign over essentially my entire inheritance, which would have been over at their house. I mean, if I wanted to keep a TV, I should be able to keep that TV. It shouldn't be, someone shouldn't look at if I got something else, then I should not get this. Like it didn't have to be tit for tat. If somebody left something for me, that's what they left for me. If somebody left something for her, that's what they left for her. But, I specifically told her that I personally didn't want anything but the pictures. Now, we eventually discussed gifting my son property because he was buying a house. The only thing we discussed, and I'm not sure if this is part of your exhibit also, I'd like to tender this if it's not.
Another text message.
Not a text message. But I'm not sure where did he leave off. What's that start on? Oh, no, that. January 21st.
Sorry, I know the video went in order. I think my exhibit looks like started 26. What is that? Universal two. Some. I think mine starts at probate is a great idea. Maybe. It's hard with screenshots. Your Honor, if you want, I can try and submit the video of the text. I don't know if that's easy for the record. We have the screenshots, it's just,
I think we need that. I mean, you've already got your printed copy, and I guess the question now is, from what he's holding, right, do you know, and can you tell whether,
I'm missing part of,
all right, then just for the ease of the record, let's now have these marked as Defense Exhibit 5. Any objection to the tendering of Defense Exhibit 5?
Is it 5, you said?
This is going to be Exhibit 5. Any objection?
no objection.
All right, D5 is admitted. And do you have an extra copy for the court reporter? Mr. Harrison?
Can I get to after I look at it? Yeah.
That's fine.
Oh. Okay, so as I stated, we were always talking about dividing property. I had already got pictures back in November. I had already got, well, I guess the art pictures also back in, I got 2 art pictures and I got some family, all the stuff that was on the wall, I got that in late November. We've already discussed dividing the cars. This was in early December. We were supposed to be dividing property, but as I stated, I didn't necessarily like going over there a lot. So we was going to set up a time where we could meet. Just prior, on January 20th, I did go over there. I can't remember for what, but Amari was there babysitting some little children, maybe 2, 3 years old. The house, in my opinion, was not safe for a little child to be there. There was knives laying. When she cooks, she just leaves everything out. There's a lot of sharp corners. And she was engaging in activities that would kind of put her in a situation where I didn't think that she would be as attentive to the kids as they should. And
Objection, Your Honor, he can't testify as to someone else's state of mind.
Overruled. Mr. Harrison.
I didn't think that they would be she would be in a position to actually be able to watch those kids. And it was a lot of stuff laying around, paraphernalia such. And, later on that day, I called her. I didn't confront her in person. I called her on the phone, told her about it. She took issue with it. She sent me a text, telling me I'm not her daddy. I can't tell her what to do. Stop being greedy. We testified to that yesterday. Sign over the deed. Well, I sent that text to my sister and told her that she should talk to her daughter because there's going to be a problem. Like she can't be, doing that. And I told her that this is our house. If something happens, we all are going to be liable. Like we can't have this kind of stuff going on. And I guess I was more overprotective because this is not something I actually had. This house was never, I control my house and I don't let certain things happen in my house, but this was now in my name also. So it was, in my opinion, it was the same thing. This wasn't an investment property. Like it wasn't in my company name at the time. This was in my name with personal liability. So we talked about it. We started discussing. She said, well, why don't we get together tomorrow so we can go ahead and divide the property? She sat back and said that she was going to meet me earlier. Well, before the text messages started or over the phone, she told me how we were supposed to, let's meet early in the morning. First of all, she told me she was going to talk to Amari about it and get her to apologize. And I said, okay. She said, let's meet tomorrow. I think it was maybe 7 or 8, whatever time it was going to be early in the morning. She stated that, we can get together. And, first of all, because I told her not only dividing the property, but at my mother's funeral, I told a lot of the family members that they would get some keepsakes also because it wasn't just our loss. It was my mother she had 4 brothers and 2 sisters. And I'm like, everyone wanted some keepsakes of their sister. I actually think she might have been the favorite sister. So everyone wanted something, but this is back in November that I promised everybody. And it's now January 21st. And I'm saying, Monique, we got to get together and divide this stuff. And she said, okay, let's meet together. So on this text, it starts off with her telling me she's on my way. I'm on my way. She says that she then tells me, hey, you still coming by or do you want to drop the thing? Do you want me to drop the things off I picked out for the aunties over there? I said, I'm coming. Had to wait on Mike. Then I say, I'm here now. Now, it stops at that point because we actually met. She had stuff that she had already taken out, costume jewelry and bags and purses and jackets and stuff like that for our aunts. She also had some pieces of art, some little small pieces of trinket art and some pictures, some other artwork that she had picked out for them. We then discussed the things that I was going to gift my son, which she was there for, that we discussed earlier. So we discussed the things we was going to give my son. We got into a heated argument over her selection because as I started selecting stuff, I said, okay, so you're going to get some TVs and this, that, and the other. It was her who would tell me, no, you can't get that TV. You got to get that TV. I said, well, what about, okay, the sofas, but you can't get this sofa. You can only get that sofa. And then, so she was like making demands about what needed to be selected. And I didn't understand why she was doing that because I'm like, Monique, I mean, this is the stuff we're supposed to divide. Like, I should have a say-so on this too. She then goes on and tells me that, well, you better check your contract. You signed it. I said, what do you mean you signed it? She tells me, you signed it. It says all contents. I said, Money, we didn't agree on all contents. She said, but you signed it. I said, okay, but this is the stuff I wanted to give my son. Are we going to give this to my son? She then selected the stuff. When we came down to the washer and dryer, I sat back and said, he wanted to get the washer set. She said, you can only get the washer, you can't get the dryer. So we decided he can get the refrigerator. We came up with a list of stuff he was going to get. It was going to be the washer. It was going to be the washing machine. It was going to be the refrigerator. It was going to be a sofa set. It was going to be 3 TVs. I sat back and told her, oh, in the refrigerator. So I sit back and told her, okay, I'm going to let him know. I had Mike on the phone. He was, going back and forth. So he was the one telling me, what about that one, Dad? Everything was. He was the one telling me, helping to pick out. We decided on what it is that he wanted to get. After I hung up, I let him know, you're going to have to get a mover because obviously refrigerators and washers, you can't move in a car. We was going to have a truck to move that kind of stuff. So we made arrangements. My sister told me at that time, just let me know when you're coming so I can do something with the food before you take it out the refrigerator. I said, okay. On my way, I let my sister know my son had already went over there. He already had this, that evening, that afternoon, it's probably about noon. He had already found a mover and they was going to be to come right away. So he was already over there breaking stuff down, taking the TVs off. He was, I think maybe removing, I don't know exactly what he had to do with the refrigerator, but I know he had to take the TVs off. He said, he called and told me that they were going to be coming over soon, asked if I could come over to help, like take the stuff out the refrigerator because you can't move it with all the stuff in the refrigerator. And I'd already told him that my sister wanted. So I came over and started taking the stuff out the refrigerator. On my way, I called my sister. She met us over there. She helped take the stuff out the refrigerator. I don't know where she put it because the house had 2 other refrigerators. I don't know if she put it in the back room or in the basement, but she was doing something with the refrigerator. But at this particular time, by the time she got there, my son had discovered a letter that had been opened and folded and was hidden. And it was a stock that was to my parents. It was to my parents and it was a stock. And I'm like, well, I didn't know anything about this. I confronted my sister about that. I'm like, Monique, why, your kid, is it you or your kids over here hiding this kind of stuff? I accused her son because it was by some stuff that he had. But she said, how you know it's him? It could be Amari. And I said, whoever it is, Monique, this is stuff that we are supposed to go over. Like, even though you're saying the contents of the house belong to you, this is a piece of mail. That doesn't mean the account belongs to you. She sat back and said, I sit back. After that, we got into, that's when the argument started. And at that point in time, I had already found out that I was the sole beneficiary. So I found out I was the sole beneficiary of the IRA around December 30th when she sent me an email telling me the whole thing was coming my way. I sat back and I asked Samantha some question about it, and she confirmed. On January 2nd, I called her because this was the holiday time. Now that I think about it, this was December 30th. My wife's birthday is December 30th. So I think a lot of things, that's also New Year's Eve and all that kind of stuff. I think I actually talked to her on the 2nd. I had a question about the taxes because since my sister stated that she was going to transfer her interest, I had already originated my process. But at that time, she said she hadn't spoken to him. So when the whole thing hit on January 30th, I had a question about just timing of the taxes. I wanted to know, would I still be responsible for the whole taxes for 2020 or 2021, how it was going to be? I called her up and I asked her, how would that work since she transferred her interest to me after I received my interest? Samantha told me at that time that no, I was the sole beneficiary. She said there was no transfer. So I said, well, I never received anything like that. She told me that she had sent me something and that I should go back in my portal. And I told her that I did check the portal, but I was looking for my cell phone and I just saw your email that stated I was primary. I didn't see anything that said sole beneficiary. She told me to check the attachment. So at this particular time, I had already spoken to my sister and told her that Wells Fargo states that I'm the sole beneficiary and that you didn't transfer your interest to me. She told me at that, she's the one that told me that it must have been a mistake. I told you before something about the contingent. I think they had us mixed up with secondary or primary or something like that, and that they was getting it fixed. They was getting it worked out. She told me that's what she was going to take care of it. Don't worry about it. So on this particular date on January 21st, when I talked to her, I think it was maybe the middle of January, once I actually told her about it. I found out on the 2nd. The whole thing came to me on December 30th. I found out on the 2nd, and I think it's probably the middle. It was probably maybe I can't remember the exact date. It was the middle of January when I actually talked to her about that. On the 21st, this was part of the huge argument that we had. So once I saw that they had hidden, once I saw they had hidden this particular tax document or this bank document or stock document, which I later found out it was, I was furious because now I felt that she was purposefully lying to me about the IRA because I had just been told that the whole thing was mine, that I was a sole beneficiary, but she's still continually to tell me that she's going to relinquish her interest and it's a mistake. We got into a huge argument. I was not frothing at the mouth, but I believe I cussed her out really good. She cussed me out really good. It was a back and forth thing. I left. My son was still there. She was there. My son was still there. It was still two movers. I left. So this text picks up when, matter of fact, when I talked to her about dividing the stuff, she said, well, if you're gonna sit back and start going that we're gonna divide everything like that, I think we're gonna need to go to probate. So I text her that afternoon at 3:12 and tell her probate is a great idea. They will force the sale. I'll check in the AM. And force the sale, I meant by the partition. I didn't realize if you could still do a partition after you had a contract, but that's what I'm telling her. They can force the sale. So the very next day, 10:48 a.m., is when I send her an update. I say, update. The bank forms that you or your children stole, opened and hid, was related to stock, which has a cash value. I am taking care of it as usual, and once processed, I will give you your 1/2 since you are my only sibling, and I don't feel entitled to all of it. Unlike how you and your family feel, you are entitled to an unproportional share of everything. Greed is a deadly sin. Please tell your kids to leave grown-up business to the adults and stay in their la-la land so they can stop complaining about money that's not theirs. I then tell her on the 26th that I went to probate court, I got the will. I suggest you do the same so you can relax your paranoia and insecurities about what you think our parents had, so pure greed can stop consuming your entire family's life. On the 27th is when I found out that they had changed the locks. I came back to try to get the tax papers because, as I stated, I always did the taxes. And so this is the time that a lot of tax forms was coming in. I was trying to get the tax forms so I could do the taxes. That's when I found out that the locks were changed. I told her, if you all don't change the locks back to my house, I'm calling the police. She said the police are the ones that advised that the locks be changed. I said, okay, can you need to get the tax stuff so I can file them for moms like I've done? She tells me that, I need to get Amari's beat pills back to her. So at this point in time, this is 5 days after my son had moved the stuff out the house, which I'll get back to because I want to go back to that video of the actual date in question. But this is 5 days after my son had moved the things out the house with her permission, with her being there. She never asked for anything back. The only thing she's asking for something back is Amari's beat pills that she says were moved from the house on Thursday, which was the 21st. I told her I didn't take any beat pills. I don't know. I said I didn't take any pills from the house, and either did Mike. She told me it's a speaker. And I said, you was there the whole time. We didn't take any speakers. It was just 3 TVs, 1 sofa. I think we did go over that yesterday. She says, I wasn't in all places at all time, but that's fine. I expected that to be your answer. And I said, I expected you to make up things we took. I tell her that Miles was there and there were movers there on police. So anybody could have took some speakers. And by the way, changing the locks is criminal. I still own the house just like you do. And neither of us can
Don't need to
restrict.
read the text, Mr. Harrison.
Okay,
Let's
so
talk about what else you think is relevant about him.
Okay, well, I was just telling her then because I'm addressing the fact that she changed the locks. And in my opinion, that was criminal. We still own the house. At this point in time, I had already told her that, that she did not pay the IRA interest. Now, I understand that I had not told her that she actually defaulted yet, but I still felt that the house was still in our name because I said I'm not going to relinquish all my rights until it's all paid for. I said, you can't restrict each other access to the house. So I'll give you a day to figure that out, blah, blah, blah. We go on a little bit more. I would like, did you say we reserved defense 3 for the video from January 21st?
That's what you'd already had marked as D3. So is that something you're wanting to?
Yes, I would like to bring that up.
I would just object to the extent, I know it was reserved. I had asked though for evidence that it was from a FOIA request or some document showing how they responded in order to provide you with that.
I'm going to authenticate it because I'm actually in the video.
Do you have any information like that of how you came about obtaining this video?
Like I stated, this was an open record request.
The request would be in writing, so there's no way of us knowing who is actually taking this video.
And I mean, that may be, but I don't know if that's necessarily, I don't think that's required for its admission. But my question to you, Mr. Harrison, is that something you received in physical mail, by email, or?
I received it via electronic. They have a portal
Mhm.
where you log in for the open records request.
You still have access to that?
Yes,
All right. Can you forward that to plaintiff's counsel?
yes. Right now?
Mhm.
What, you mean forward my passport code and everything, or just a portal?
Is it, you need a password in order to get into the portal?
Yeah, it's a secure portal.
Okay. Well, why don't you
Like-
just forward the email just showing that you got it through a portal and
I just sent you one.
all right. And now that that's been sent, there's a prospective objection to D3 based on foundation and authentication. So if you want to lay any further testimony in regard to that, and then you can tender if you feel you've adequately done that.
So I can authenticate to this video because I was actually there. This is when I walked up on the scene, the police officers were present. The police officers captured me on video coming to the basement, speaking with my sister regarding the argument that we had. It shows me leaving. The video actually comes up onto the driveway and shows me leaving the driveway. So, I can authenticate to the validity of the video and that it is accurate to what it shows.
All right. And you're trying to admit this video in its entirety?
Yes, I would like to admit the video in its entirety because it shows Ms. Harrison has testified that even though she gave permission for my son to have it, she still did not want it to be there. She still did not want him to take it. And she said, she's testified that I was so violent that she did not want to interfere with anybody taking it. And I want to show that I was not there the entire time. And I left while the stuff was still being moved. And I also want to show a couple of admissions that were made on the tape that's regarding this lawsuit.
All right, any further objections to D3?
Your Honor, yes, I don't see how he can authenticate the video while claiming he's not there
No, I was there.
the whole
I
time,
can't.
and that the video is for the purposes of showing that he wasn't there. He can just merely testify to the fact that he wasn't there.
All right, well, as it relates to authentication, I think for the periods of the video where he is there and he's testifying that the recording is accurate, that would be admissible. At the moment he leaves, that portion of the video, he would not be able to authenticate. So D3 is admitted under those restrictions.
Okay. Do you still show me a signed in, Ms. Sue?
Yes.
Are you able to? I'm getting that echo feedback.
Same thing as what happened yesterday. However, Mr. Derberry showed you how to pull it up. You need to do that again and mute your computer.
Are you able to hear, Your Honor?
Mr. Derberry?
Can you have, he needs to mute the computer completely right there. Click on it. Where your cursor is, click. You moved your cursor. Move your cursor down to click on it.
Right here?
Yes, click. You move it onto the speaker and click on it.
I'm on the speaker icon.
Move it down.
Okay. Go back where you were. Click. Okay, now move it all the way to all the way. Yeah, there. Now, when you got on Zoom to share your screen, there was an option to share video. I mean, share audio. You had to click that or else you're not going to hear anything. Try it, see if it works. If it doesn't, get out of it and start over. Do, do not unclick that.
You have to leave the meeting and re-enter.
Leave the meeting. I apologize, Your Honor.
But once you hit share screen, before you do anything, there's an option for you to share audio. Click on that and then continue.
Share sound, right?
Correct.
Is there anything else I'm doing wrong?
Okay, I'm looking. I cannot tell if you need to completely mute your computer. And I'm not sure what if the X there is the how to mute your computer completely. It's going to be take your cursor all the way down to the right, over here to this. Oh, go back to where you were.
Right here?
I can't see your.
Move over two. Move over two spaces to the right, right there.
That right there needs to be muted. Come down below. Keep coming. Come.
Right there.
Mute it. If, then I think now you need to turn that, put the X back on if the sound's not coming out. For right on, move your cursor to the right, keep going to the right, keep going. You moved it too low. Move your cursor up. Not there. Yeah, that's fine. Leave that X right there. See that? I'm not sure where you're at now. Leave that X on that right there.
I think he's saying in the video where you have an X on that little microphone down at the bottom right of the screen to
the
turn that
video.
sound back on. Over.
I got this.
Over a little more.
All right, we're going to break for the lunch. I have afternoon hearings. We'll resume at 2:15. Mr. Harrison, I advise you to use that time to figure out how you're doing it, how you're going to use your exhibits, because we have to move on. We'll be in recess until 2:15.
Mr. Harris, I will help you.
Thank you.
Move your. Now move slowly with your cursor. Come down, come down, come down, come down. Now slow down. Now move to the right. Keep going.
I got all these. Oh, okay, here we go. Okay. I have stuff in the way.
Oh, that's click on it. You didn't, I'm not sure what you did. You didn't, the X is staying on it. The X should be removed.
Oh, yeah.
Mm.
It's moved.
Now start the video.
How you doing, Mal? What's going on?
Thank you.
You're welcome.
Thank you, boy.
You're welcome.
He probably has a 1:30 calendar, right? Yeah, so I'm assuming if he has a 1:30, he has hearing, so we have to probably take all our stuff with us.
Yes.
Once you start switching between.
I know.
pages.
I wanna help you, but I don't wanna.
No, you're fine. My mind works like this anyway. I'm organizing.
I'm the same way. Drives Reggie crazy.
What?
I said drives Reggie crazy. I have to,
Little ADD?
yeah. Probably not a little.
It's all gonna be about Zoom, so y'all can leave it.
Oh, okay. Thank you.
If y'all do this,
Won't be anyone in the room to watch it, right?
Hmm?
There's not gonna be a sheriff or anyone here, right?
No. I'm a lot of stores.
Yeah.
Oh,
I was worried about it.
I
So
know,
I
I'm
would leave
glad I
everything
did too.
here.
Access.
Oh, this week, this week?
Well, I mean, what you talking about for today?
No, I just want to see Jerry.
Okay.
Do you have to know if Boyd Derryberry's, is his family from Ohio?
I don't know.
Yeah.
No.
It's not a very common last name, I'm assuming.
Yeah, no.
It's
no.
not related.
That's your family name? Or you
No.
have family member, oh, you know someone that has that family name?
Yeah, I know someone who's, that's their cousin.
Oh, really?
Assuming.
That's a coincidence. My life.
We're still on, we're probably still on live feed, so.
I said, no, yeah, because they're still recording. Yeah. Yeah, another hearing.
In here, if you guys want to sit in there, here in the hallway, if y'all go do lunch or anywhere, and y'all want to come back to some conference that open up.
This right here?
No, outside.
Oh, okay,
By the bell, before you get to the bathrooms.
okay. So we could go in there for lunch or
Yeah.
whatever. All right, thank you, I appreciate it. Just trying to get, everybody know now some of these documents.
while I have the moment, I want to mention, was it your fiance's name, Reginald? Reginald Brown. How do you spell that?
Brown, like the
Oh,
color.
Brown.
Yes.
but-
And A.
Oh, okay.
I like.
We've called him Reggie.
Yeah, we
Okay,
called him
okay, because I
Reggie
was
before,
like, did I
yeah.
hear Revy or Reggie? Okay, okay,
Reggie.
just making sure for the record. Thank you.
You're
Thank you.
No problem.
Come to order, remain seated.
All right, let's go back on the record. Thank you, everyone, for being back and on time, ready to go. Anything we need to take up before we resume on behalf of the plaintiffs?
I don't believe so.
Mr. Harrison?
Oh, sorry. I was just gonna say, if, after this is done, and before we rest our case, do you want me to do attorney's fees prior to that moment or wait till after he puts his case on?
I think we would do it before you rest your case. All right. Mr. Harrison,
No, sir.
anything? Okay. Then you can resume. Mr. Harrison, though, in the interest of trying to wrap everything up today, I think we've had you testifying for about an hour and a half now. And so I want to set a time limit of no more than another hour. Okay? You can do with that time the best you want, and we'll go from there. Do you think that's going to be enough time for you?
I mean, it should be enough, Your Honor. I didn't get a chance to talk, yesterday.
Well, let's see where we go. But I want to see if we can fit that in. And I'm not counting objections or miscellaneous, but
Okay.
I feel like the ground we need to cover, we should be able to make a lot of progress in an hour. So we can reapproach, see where we are. You can tell me what's left when we get to that point, okay?
Okay.
All right. Back to you, sir.
Okay, so I was setting the stage for this particular video. Like I stated, my sister and I had just got into a huge argument on January 21st, 2021. It was over a few issues, but it was primarily over the IRA. It was primarily over some stock papers that I had found and was hidden.
Can you pull your microphone down?
It was primarily over some stock papers that were found that was hidden. And it was over the cars and it was over the contents. At this particular time, it's the first time I had heard that Miss Harrison said the contents were in the house, was part of the contract. I had to remember when we actually did the contract at UPS store on December 17th, Miss Harrison swapped out the contracts. And so at that particular time, I had to recall that because what she stated was that the contract that I had, which did not have contents in it, swapped out buyer and purchaser. So she took that as an issue and she had her own contract and wanted to use her contract. I did look over it at the time, but this is not a contract that I read prior. While we was at the counter about to execute the contract, she told me to look at it. I paid attention to all the monetary things and things of that nature that we had discussions about. We had never had discussions about contents, so I never thought about looking if structures was before contents or contents came after structures, because there's only one word that she added, which is contents. It's not something that we contacted. She just told me about that, so I'm furious about that. So at this particular time, I'm bringing up the fact of how she's not the beneficiary of this IRA, and I've been telling her, and she's been ignoring me the same way she's ignored before. And she's just acting as if she's still the beneficiary, as after I'm telling her that she's not. She's breached the contract, so you don't own the contents. You don't own the house. You know, we got to make an arrangement on this.
And how do you contend she breached? I know you're saying if upon learning she didn't have any interest in the IRA, all right, now she owes you an additional 43,000. What was the date that 43,000 should have been paid to you?
It states that the contract should be deemed paid in full by September 17, 2021.
Right.
And that's part of the compensation. That's part of the consideration.
But the text you sent her was, you have 10 days to pay me now that I've learned you don't have any right to the IRA, right?
Which text? Which one? Oh,
In
so that was in
March.
March. That was in March. At this time, I'm still in January, so we haven't.
Sure. But I guess you just said that she had breached when she finds out she doesn't know the IRA.
Well, at
doesn't
that
belong
particular
to her.
time, we're arguing. Like I said, we're in the middle of an argument.
But in January, she hasn't breached.
Well, I mean, in my opinion, she still breached, because if she was not the beneficiary, that's something that she couldn't fulfill. Like, she told me she was the beneficiary.
But all she has to do is pay you.
At that time, you're right. So that's why
By
in March,
September.
by September. And so in March, I did give her the opportunity to cure. So,
But
So-
cure what? It's not September yet.
and that's why I never pursued anything.
Okay.
Yeah.
So where'd the 10 days come from? Even if she's not the owner of the IRA, she's got until September to pay you the balance, right?
Right.
So the 10 days was just something you kind of made up.
Well, I thought I had to give her notice that she had breached. I mean, so if she was not the beneficiary of the IRA, I thought I had to give her notice. So I gave her notice and gave her 10 days, but I never enforced that 10 days. I did put it in the contract. I mean, I did put it in the email. But 30 days later, I sent her another email. And then I said, and I didn't give the email that I sent her, didn't give her 10 days to pay. It gave her 10 days to make arrangements on how she's going to pay. So it wasn't a final notice. It set back. The email I sent her thanked her for making her payment, but unfortunately, you're not the beneficiary of this IRA. So therefore, that drastically reduces the amount that you're going to have to owe. I'm going to give you 10 days to make arrangements on how you want to rectify this situation. I'm not sure that's the exact words, but it was rectify, or I know I said make arrangements on how to do it. All I was expecting, because up until this time, she was just ignoring it. No matter how many times I told her, no matter how many times I talked to her about it, she just ignored it. In the beginning,
So I'll let you get back to January. Since we're on this topic, what is the exact date that you contend she breached her contract, her end of the deal?
so in March is when, in January, I found out that she was over the phone. Samantha Hayes told me that I was the sole beneficiary. My sister is still contending that she is the beneficiary and it was a mistake. She constantly told me it was a mistake and she was going to get it worked out. In March, after the January incident and all this kind of stuff happened, I reached out to Samantha Hayes and I told her I was having an issue with my sister. My sister was telling me that she's the beneficiary also and that everything is a mistake. I asked her if she could send me documentation that showed that I am the sole beneficiary. At that point in time, she told me she had already sent me something. I told her I never got anything. She told me to check the portal. I checked the portal. Nothing was in the portal. She told me she was going to resend it, which she did.
Okay. I'm not really getting into all those kind of
Okay.
details. What is the
So-
date you think that she should have done something and she didn't?
By September 17th, 2021.
Okay.
Yeah, so by that date, at that particular time, I had told her, and then I sent her another email or another message in April. And at that point in time, I told her that she's going to, that I felt like she breached and I need to take legal action. If you don't respond, I'm going to take action.
Okay. All right. You can pick it back up wherever you'd like.
Okay, so we're having this argument. And like I stated, I felt I was confused and furious at the same time because I know we never discussed contents, yet she's telling me it's in there. Just check the contract, read the contract. I know she's telling me that it's a mistake with this IRA and she's going to get it straightened out, but she's refusing to talk to me about it and deal with me on it. She's not adhering to the terms of what we decided how we was going to divide these cars. And Oh, like I said about the stock. So she sat back and it was a stock that was hidden. So that's really what triggered it. I'm looking at why would anybody in this house take us open mail that belonged to my parents, which me and my sister should have been dealing with, and why would they open it and hide it? I didn't understand. So I asked her about that. And she told me, because I'm looking at it, is either you are with them helping them do this, or they're doing this behind your back. We had a confrontation about that. We argued. I left. But like I said, my son, the later on, my son came. He sat back and let me share my screen. Got to join the meeting again. My son came. He finished moving while I was there. I came back over to the house. While I was there, I helped take the stuff out the refrigerator, as I already testified to. My sister met us over there. At no point in time did she ever, tell us not to take it. At no point in time did she ever tell us to bring anything back. Every conversation that we had, although we were arguing, I left while we was moving the stuff out the refrigerator, so I didn't have any confrontation with her. Unbeknownst to me, someone, I guess, saw the whole thing through the video, through our argument, the video that they originally claimed was broken or stolen. They saw the video. Somebody called the police. I later learned that it was her son, Miles. When my son, I just need to, can I just pause for, let me just put the video on. I know the time frame that I have, so I didn't think I was going to be logged out. It says host is disabled me from sharing.
Probably need to add you again as a co-host, perhaps. Just hold on for a second.
Okay.
They got a lot. This is nice back here.
As I stated before, this is on January 21st. This is the day that they claim in their conversion claim that everything was converted. The original conversion claims stated the bulk of everything that they state was converted was on January 21st. We've already seen the video where she's admitted that she did give these items to my son.
I'd object. I don't believe Mr. Harrison is present at all. I believe
We're going to get to the part where I'm present. I thought we were going to authenticate that.
Well, so we do, what I said was the parts you're present are the ones that are technically for consideration for the record. So
Okay.
let's move to those parts of the video if you have time markers for those.
How old are you? So who's listed? It's not a problem.
Okay, so this is when I'm showing up.
Yes, sir.
Even if you're in,
Yeah, I'm coming back up.
be like if it's a typical mortgage like, then yeah, you could go right away.
It's not a problem.
Everything could,
Everything good.
but,
Who are you? Oh, that's your brother. Okay. We just got a call. It wasn't nothing crazy.
Flexed a little bit. I did cuss her out. I cussed her out because they did some real shicey stuff. I didn't put no hands on her, nothing.
Yeah, she said that, and he didn't say that. Nobody said any of that. Nobody said nobody was the aggressor. Nobody said that. The way the call came out,
Miles.
the way the call came out, he just was like his mom and I guess her brother got into it and he didn't want nothing to escalate. That's it. If my mama, you know, he got every right to feel like that about his mom.
Feel like that all you want to.
Right, but he didn't say,
Since she's stealing money from her.
he didn't say nobody was aggressive though, y'all.
This is a conversation I'm having on my phone. Your $3,000. Where is that? Going towards your car?
And you wanna know how much my car was? You wanna know how much my car was?
We look, we ain't gonna do that.
And it's not being slick. I already told her you was supposed to give him money.
She wanted to give all her grandchildren $3,000.
Yup.
And my dad goes, shut the fuck up.
Yup.
My dad,
Hey, bro,
Miles,
come here. Miles, come here.
My bad.
Miles, come here.
Because I thought it was real. Just like
Miles,
that.
Y'all like that. I'm just like that. Relax.
Just like that.
And that
Lexus, Lexus was supposed to be divided by the grandchildren.
Sure.
I gave it to you for
I
your
said
fault.
you can
That's
have
what
it.
we did.
For sure.
And y'all run that shit.
For sure, bro. I'm not even.
Don't worry, it's
I'm not
cool,
even.
Miles.
Y'all see how the way
It's just a family rivalry. Me and my sister ain't never got
Don't call
along.
me for
We
nothing.
ain't never got
Just
along, and then
ask me
it's just
for
exacerbated because I want too much stuff spelled out.
What is your
Both my
son?
parents, that's my son.
Okay.
Both my parents died in
You
2020.
just act
It
like
wasn't
I
nothing
asked
set.
for $1,000, bro. I asked you for $20, bro. You want that back in my face? You want the, bro, y'all.
Mike, don't talk to her.
Ricky,
Don't talk to
I
her.
understand. I understand.
He ain't asking for that.
You understand? If this was your mom,
Miles,
you
I
would have
said
did the
no
same
more
thing,
word.
bro.
Miles.
Okay, relax. I understand. But I'm just saying though, this has been going on too long, bro. And I'm not even cussing you
Make sure
out,
these moves good.
bro. That's crazy, bro. That's crazy.
It is.
If this
Well,
was
let's see.
mama,
For okay. So for right now,
mama would be the same thing, bro.
right now, it seems like it's a little, it's a little aggression here. It's hostility. Who leaving for a time being?
I was gone.
For
I
cool.
just came back.
Yeah, I know I heard he called you. It's cool.
I'll get out of here. Don't nobody. Let me ask you something, officer.
Go ahead.
This is both of our house right now until she finishes the sale.
How-
What
how-
do I need to do so nobody can stay here till we finish the sale?
How is your well, you can't do nothing because first of all, she got a part on the deed just as well as you.
So therefore, I can get what I want out the house just like she can. Right?
it'll be silver. We ain't got nothing to do with
Exactly.
that.
It's simple. If that's what you want to do. You say you want to do probate, let's do it.
That
They
case-
gonna sell
that
the
case-
house.
that
And
case
it's not
is-
going to go to you if that's what you want.
Yeah, that
I
case
was trying to
will
work
be
with
civil.
you. This is the deal you came to me with. You talk about the money situation, man. This was her idea. This is her idea.
Look,
Your money
this is all I
situation ain't no
said.
problem.
Look, this is what I said.
But how are you listed on the
I'm just
deed?
saying, bro. You act like I said.
No, how are you listed on the deed as the buyer or the seller?
We are on the deed. We are both the owners.
The owners of
And
this house.
then we got another contract because I wanted to sell it. She wants to keep it. So she's buying my part out. We have a contract. She came to me and said she wants to buy me out. So we have a contract, a purchase sale, kind of like a lease purchase until X amount of days. And
When is the contract up?
It'll be up in she got to make her next payment in March. If she doesn't make that, it's up. We sell it. If she makes that payment, June. If she doesn't make that payment, it's over. We sell it. That's in the contract.
This y'all parents' house?
This was my parents' house. And see, the thing is, this house is 50 years old, right? Everything is bad. I was handling all the stuff with my dad. When my dad passed, I was handling everything for my mom. I know all the ins and outs of what's going on with the house because I was doing it. I know how old the wiring is. I know how old the plumbing is. I said, Monique, it's not worth it because something's going to go wrong. This man right here, every time we have flooded this basement 3 times, it was all his fault, according to Papa. According to Papa.
Papa used to say that you
According to Papa. Okay, so according to Papa. So we've had to renovate this. This is the 3rd time it's been renovated. This just got renovated. My dad was in the hospital. He never even saw it because he was in the hospital so long. By the time he passed, it just got finished at his funeral. So I'm sitting here telling her, Monique, it's not a good idea because it's going to flood again. This is going to happen. This is all the stuff we got to get. Let's just sell it, split the money, and then you can take care of your family. So he's not talking about he got money problems, whatever he talking about. She chose not to. She chose not to. So right now, she has a problem with her daughter is staying there, and I ain't had no problem with it because she was staying there.
I got you.
Yes, but it's just started getting escalated because for some reason they think I don't have no say so. So just like you said, we have. So just like
What you think, McCain?
If you're in the process of selling it, it's a typical buyer-seller contract. So as far as property belonging to your parents, if you don't come to an agreement.
no, we have a
on it,
deed. We got a deed. The deed is
it
an
doesn't matter.
Okay.
What I'm saying is, if it comes to a point where there's a problem about who takes what property from the house, then you have to have it probated.
Exactly. And
And
they
so
want
the
to sell it at
judge
auction.
decide who take a judge will decide who takes what from the house.
Well, from what I understand, they
As
said they
far
split the
as-
property. And if
Just
they
make sure
can't
you
split
do it the right
property-
way because you don't need to come back and get sued.
Yeah. Well,
So probate
Who splits
court,
the property?
they say whoever, if you got joint tenants, they will split the title. That's not usually because it's overall. So like if you had land, if it was easy to split the land, you get half and I get half. But if it's something like a house and you can't come to an agreement, they say they will force a sale.
Or did
And
you
then
and
split the
her come
proceeds.
to an agreement on selling the
Yeah,
house?
yeah, we got no-
Okay,
yeah.
then you don't have nothing to worry about.
Yeah, no, we ain't got nothing to worry about.
Okay.
Cause I'm actually going through the same very thing with my brother right now.
Okay. So you didn't decide to keep the house?
No, I'm keeping it.
Oh, you gonna keep it? He wants to sell it. Okay.
Everybody's entitled to feel how they want to feel.
Exactly. That's
You
all
know.
I'm saying. But this all sparked because for some reason she spread to her family that I'm being greedy because I don't just want to keep the house. So now her daughter talking disrespectful to me, talking about some, if you just wasn't so greedy, you should just, if you got a problem with the liability, because she was babysitting some kids over here. And I said, I don't feel comfortable with these kids being babysat over there. I told my sister, I didn't even go to her. The next day she kept doing it. And I said, Mari, it's not comfortable. It's a 3-year-old and a 7-year-old. If they get hurt in their house, we're going to get sued. And I said, it's just better to go back over to their house where they would have been. You can't tell me what to do. This ain't your house. And then she started telling me, if you got a liability issue, why don't you just sign over the deed instead of being so greedy?
Well, here's the other thing, the liability issue, since you're in the buyer-seller state, the liability issue is gonna be on her.
Oh, is it? All the way?
Mhm.
Oh, that's good to know.
You're not responsible for homeowners or anything like that.
Even though I'm still on the deed.
Yeah.
Because y'all going through the process.
Great to know.
But she can have those kids in here.
But she can have.
I know she can.
Yeah.
I would tell her it's not a good idea. I told my sister, I said, I don't think that's a good idea because if they get hurt.
If they get hurt, then, and he said he thought that somebody, like if the mother wanted to sue, that they would sue him.
No, they gonna
Which
come
I
after you.
understood, right? And in the contract, it says I assume liability.
Oh,
From the
okay.
date of signing of the contract, and that was understood. My daughter she's a nanny, and the kids were supposed to be back in school, but because of quarantine, or their school had to quarantine, the kids had to be home this week.
Mhm.
And so she has a small business that she's trying to start and that she's trying to work down here, whatever. So she just thought it would be easier to bring them home with her while she's trying to do her thing and then take them home.
I got you.
And I told her she was out of pocket to speak to any adult like that, especially family.
Mm-hmm.
I told her to apologize, but I don't make anybody.
When y'all
do
parents passed
anything.
away?
Mom passed away in February. Mom just passed
Y'all
away.
gonna have to get it together. Y'all family. Y'all all y'all got.
I keep
That's
trying.
what I thought. That's what I thought.
And the crazy part about it, but the thing I'm hearing, y'all jumping out his throat, but he really ain't saying nothing bad about none of
I
y'all.
don't know nothing about nothing. I just know he said Miles called the police on me.
Yeah,
so I'm over here.
he wasn't-
I'm over
he
here
didn't
getting the
speak-
police called on me.
He didn't
So I
speak.
don't take kindly to it at all.
He didn't speak negative at all. We didn't come. If it was that kind of call, y'all would have knew who would. It would have been more than just us two.
But my
You
sister has
know?
always done that whenever because I am passionate. So when I start talking, I get into it with her. I mean,
Brothers and sisters argue.
all the time. But she always does, and she's done this several times. She'll call the police and just have them sitting there. She likes to do that kind of stuff. And so this time she must have did it with Miles, and then Miles.
No,
called the police.
Amari called me and said that
How's Amari
something
doing? So
was
she wasn't
going
here?
on. So I said no one was answering the phone. So I
Can I
called
go
the
to other
police.
people?
Yeah, you're free to go.
All right, I
For
appreciate
sure.
it.
Y'all have a good day.
You good, my talk? Yeah, she got right.
I don't need y'all for nothing, bro.
I just wanted to point out how I left. I'm leaving now.
That's fine. I'm not. I swear I'm not, bro.
Miles Carter is going to follow me behind me, harassing me, talking trash. And he was walking behind me.
You're right. Let me be fake. You're the fakest out of them all.
Let it go. Let it go.
Y'all got to learn to bite some bullets around here.
This is how
I held my tongue for too long. It's been going on.
Don't be stopped. Just
So, okay, so I'm no longer there, but I can testify to what happened. He walked behind me, following me. I have an Audi 2000 A6. I have an Audi A6. My car was in the shop. I happen to have a loaner vehicle. He's walking behind me, still talking about money. He's walking behind me saying, "Yeah, Uncle Jimmy, nice car, nice car. Is that Papa's money? Papa's money?" I mean, it was just harassing me. And I'm sitting back telling him we're not going to be able to see it because I can't authenticate it. But he walked behind me, telling me that
Objection is to what's hearsay, relevance.
I heard him say it.
Well, that doesn't necessarily get you bound to hearsay objection, but I think there are other exceptions that may apply here. What is and the relevance here, Mr. Harrison?
The relevance is that they've testified that I was harassing them. They've testified that I was the one on this particular date that it was so hostile that She just did not want to. She was fearful for her life.
All right, overruled. You can continue.
Okay, so he walked behind me, nice cars that Papa money. I had to sit back, so then I started jacking off with him a little bit. Last thing I told him was to learn how to read, and that started into a whole other argument, but I got in the car and left. And my son was still there, my sister was still there, Miles was still there, the police was still there. At no point in time, as you can see in this video, did she ever relate to them. They didn't even come because they thought someone was converting something or stealing something, or I was breaking in, taking anything without permission. We had an agreement of what my son was to get. It wasn't even for me. After this date, I already showcased the text messages that I testified to already. The text messages that I testified to already, which shows the next day I came because I was trying to get the taxes. I came to try to get the taxes. The door was locked. They had locked the doors. My sister said one of those officers told her, Officer McCain is the one that told her that he can to change the locks. The other officer told her not to change the locks.
Objection, hearsay.
All right, sustain.
So she changed the locks. Anyway, she changed the locks. I asked her about it through those text messages. Why would you all change the locks? She specified in those text messages that the officer told me to do it. And I sit back and said that you need to get me the tax records. She told me, why don't I return Amari's pills? In the text message, which I've already testified to, I don't know no one took any pills. And she had to specify that they were speakers. She asked for some speakers back. I sat back and said, no one took any speakers. The only thing my son got was the 3 TVs, what we agreed to, the 3 TVs, the refrigerator, the washer, and the sofa set. And she said, but he wasn't supposed to get the speakers. I said, I don't know anything about those speakers. On the 17th, at that point in time, I'm locked out. I can't get into the house anymore. We're not having any conversations, but we are having text message conversations. On the 16th, I would like to show this to you, Mr. Medemeyer, if this was a part of your. February 16th, 2021.
No. They were part of the video that was shown. But I don't believe they're part of the screenshots unless I missed them.
And I would like to introduce these to the record.
All right. What are they?
Testify. This is text messages between myself and my sister, February 16th, 2021. It shows
All right, so we have further text. Tender to, we'll mark this as D6. Is there any objection to D6?
No, Your Honor.
All right, D6 is admitted. And again, Mr. Harrison, I'm going to need you to provide copies of these to the court reporter before we conclude.
Okay. Okay, so this is the next time that I came to the house. At this point in time, as I testified, we were supposed to be dividing cars, but Miss Harrison was withholding the keys to the cars that I was supposed to have. I could not get the keys, so I came over and I got the 2000 Jaguar that was in the driveway, where she testified earlier that she has no idea what happened to it. But this car was already titled in my name. The car was titled in my name because while my father was sick, he tasked me with selling the cars. My mother did not want the car sitting in the driveway. She felt, as my sister testified, she's a neat freak. She felt that it was just taking up space. It was ugly. She wanted my father to sell it. Well, he asked me to do it. But I could not sell the car without he transferred the title into my name to try to facilitate that sale. Once I tried to facilitate the sale, he wasn't comfortable with the amount that it was going to return. He didn't think it was enough. And so he got sick, and the car just stayed in my name. I never testified that this was my car, but it is legally in my name. But as I stated, my parents had 4 cars. This was one of the cars that I'm always saying this was my mother's car. So it has sentimental value to me. But so once I did that, she texted me, and how are you going to justify taking a Jaguar without so much as a word? And I say, maybe it's the same way you added all contents to our contract without so much as a word, or how you changed all the
I've read
locks.
it now.
Okay.
I need to get it reread.
Okay. So I asked her about that. She goes into the fact that, it's the whole situation that she stated.
I've read the whole exhibit. What else do you want me to know about it?
What I want to just point out is the fact that I asked her, are you not going to, since she locked the house, are you not going to give me and my son a chance to get any keepsakes? Because up until that time, we had equal access to the house. Everybody had a key. Miles, Amari, my son, my wife, my sister, me. I'm not sure if Monique's boyfriend did or not, but they changed the locks, and now I'm not able to get any of the stuff that we talked about me getting as far as paraphernalia, or as far as keepsakes. And she stated that you had plenty of time to get whatever other keepsakes that you wanted. This is when she first tells me that this car, even though it's titled in my name, is hers because of the contract. She said that it's included on all contents therein. She said you had whatever time to get whatever keepsakes that you wanted. When you took the artwork, daddy's fraternity, paraphernalia, and mommy's sorority, she's including the artwork as keepsakes. She's not comparing that to something that I stole, which is what she's trying to say I did with the car. She says I stole the car, but she says the artwork is keepsakes. And that's important to understand, because this is what we have discussed. This is what we discussed about splitting it. She never, ever said that I stole anything up until this particular lawsuit. Okay, so right around this time is when I put the house in the JLMBL's name. I was not able to get into the house, and like I stated, the kids was over there all the time. I transferred the house in the JLMBL's name because I was still liable for the actions that's going on over there, and it was nothing I could do about it. My head was so, as I stated, confused and furious at the same time, because I just didn't understand what was going on. I felt like, even though we had a situation that we were supposed to be abiding by this contract, and she's telling me she's not going to pay me because she's just ignoring everything. I know that they're over there taking things through the mail that I have no idea what's going on. In my mind, I had already determined that she's straight out lying to me about the IRA. So, I said, I'm not going to be responsible for what's going on. Let me put this in JLMEL's name. After this time, I reached back out to Samantha Hayes, as I just testified earlier when you asked me, I reached out to Samantha Hayes to let her know that I was having a dispute with my sister. She was continually telling me that she was a beneficiary of this IRA. She kept saying that it was a mistake. That's the only thing that she ever told me. And I wanted to get confirmation on it. She told me that she had sent me something before. I had not seen any beneficiary claim form, so I did not know what she was talking about. She told me to look into, she told me to look inside of the portal, and I guess the messages inside this portal, they disappear after a certain amount of time. So there was not anything in the portal related to anything that she mentioned. She told me she would resend it. That is part of the record that Mr. Lettermeyer has already provided. Inside of his the Wells Fargo documents, not only does it show the email that he's referring to that states that I should have received this earlier, I did not see that attachment earlier. So she resent it to me, and you have that inside of your documents where she says I'm resending it. So she resent it to show me. At that particular time in March is when I actually for the first time saw the beneficiary claim form. On March 17th is when my sister made that payment, and then I responded with the text message that I did, telling her I had just learned this and just learned that, and she has to make some type of arrangements because she's not the beneficiary. At that point in time, I had confirmation. On April 26th, I sent a second demand letter. That second demand letter, as I stated earlier, just, told her that she was in breach. And at this point in time, I felt that she was in breach of the contract.
But you said earlier, though, that she wasn't actually in breach until September.
That's what I'm saying. Once I had some people look over it, that's when they told me, and this is why I never pursued anything. So all I did was get with an attorney that sent something. But she actually had until November. 17th, 2021.
September, according to the.
I'm sorry, September 17th, 2021. So I never, I just never pursued it. But I was trying to put some heat up on her to let her know you're going to have to do something. I mean, you can't just sit around and tell me you're not going to pay. This is what I was thinking. But I did give her a demand letter because technically, if she was not the beneficiary of the IRA, she could not relinquish an interest to me. Now, she could have cured it, which is what I was trying to give her an opportunity to do. As we know, on June 3rd, she sued for conversion, but she sued for conversion of
Repeat the last statement one more time, sorry.
which last statement?
Something to do with you tried to give her an opportunity?
Why don't we ask the court reporter to read that back? Maybe that's something she can help us out with.
You might want to come closer to hear it. It's on the laptop speaker. I apologize. It's fine. And if this isn't the one, then it's probably the next one. I know, I'm sorry.
All right, Mr. Harrison, you can continue.
Okay, so, as I stated, once I sent that to her, she filed a, this action that we're in right now for a conversion. She stated that it's conversion of the IRA. And, she said financial accounts and, other things that she listed. But as far as tangible assets, it was the things that she, from January 21st. I did not convert the IRA, and she was using that as an attempt to get out of, in my opinion, she was using that as an attempt to get out of paying the portion of the IRA by saying that I converted it. So, I know I had the information from Wells Fargo, but, we still had to get to the bottom of what she was trying to say that she claimed I converted. But we counterclaim with breach of contract. The counterclaim came from breach of contract because even though she had an opportunity to cure, I still gave her, she still was technically, she was not a beneficiary. She had no interest to relinquish. So my attorney.
Filed that counterclaim in July.
Right.
But the money wasn't due until September.
Right.
Had she actually breached at the time you filed that counterclaim?
If she did not, if she promised to relinquish an interest in IRA that she did not have and she knew she did not have, because at the particular time, she could not have filled out any beneficiary claim forms. She could not have filled out any disclaim forms. She represented that she had spoken to them and gotten everything straightened out, but that was not the truth. So technically, she could not relinquish an interest in the IRA.
But she could still present you with a check for $43,000.
And I was asking her about that, and she would not do it. And by September, she still did not do it. She still did not do it. When they filed a motion for the conversion claim, they also filed that TRO. My attorney at the time told me that, if you didn't do any of this, then there's no reason why you should try to go over there because you'll be setting yourself up. So I consented to the TRO simply because if she was going to accuse me of converting the stuff that she clearly gave to my son, I know they would say anything about something that I took. I did not want to put myself in that situation. I consented to the TRO. After I did win that motion for summary judgment, which was reversed.
And Your Honor, it's just relevance, and we have a Court of Appeals order. I don't see the relevance of an order that was overturned.
Right now, all he's done is use it to place a time marker. So what
That's
were
the
you gonna
time
say,
mark.
Mr.
Okay,
Harrison?
so
Overruled.
so I won that motion for summary judgment. We had the trial on June 1st. The hearing was set. The order was signed on June 10th. That final order at that time stated that we should, according to the terms of the contract, sell the property and split the proceeds. She was to give me the key to the house because they had locked me out the house. We were to split the proceeds and things of that nature. But we were supposed to sell the house within 30 days. So once they did that, I was attempting to follow the order that we had. I started to contact real estate agents. I started emailing and texting her every step of the way. They just refused to respond to anything. But we were trying to get the house sold according to the contract. I mean, according to the final order that was at the time. But at that time, there was more altercations between myself and mainly her children because they were at the house. But we've discussed that. On the 9th, on the 15th, they had to give me the key by the 15th, and then that is when they, moved out. When they moved out, I came up on that day because she was supposed to be giving me the key, and I met her to get a key that was supposed to be the key to the house, but it was not the right key. But, I saw the trucks full of furniture that they were moving out as if they were not coming back. I'm not sure what all of the stuff is. I did see some of my parents' stuff. I saw stuff that I didn't recognize, but they were moving out as if they were not coming back. During this particular time period, a whole lot of events happened. Ms. Harrison did go ahead and put the money into the registry at that time, but there was no order to put money into the registry. The TRO that we had ordered her to pay installment payments into the registry. It never ordered her to pay that $43,250 into the registry. It specifically named the June installment payment and the September installment payment. Mr. Lettermeyer was attempting to get me to accept the $43,250, which I denied each time.
Objection, settlement negotiations are not admissible.
It wasn't a settlement negotiation. It wasn't confidential.
All settlement negotiations are confidential.
All right, I don't need to follow up. That's saying we don't need to get into conversations between you and opposing counsel.
Okay. Well, they put the money into the registry without any kind of agreement, but it was well after. It was on June 9th, 2022. On June 16th, like I said, they moved out on June 15th. On June 16th, Ms. Harrison probated the estate. At that same time, because of the altercations that I was having with her children, I filed the TPO against them individually, Miles and Amari, which we know how that ended up with this bill of peace. We had that particular court hearing on July 7th, I believe, and on July 8th, they then appealed my motion for summary judgment. From that point on, once they filed the appeal, the only reason we were at the house up to that time was to get it ready for sale. We had a purchase contract for $580,000 on the house. We had to rescind that offer. We had to rescind that contract.
Objection just as to the classification of we. It's,
What, you just don't like how he's answering?
well, the implication is that him and Ms. Harrison were both, in a listing agreement and then had an offer from a party.
I think you can clarify it on cross. I don't see that as grounds for objection. You can continue your testimony.
The offer had to be rescinded. Like I said, they refused to sign any of the paperwork. And once I knew that we could not sell the house, there was no reason for me to go back to the house because, as I stated, I didn't necessarily like going to the house because I always felt, especially my mother's presence. And it was more so sad for me to be there. I didn't like being there, but no one in my family went back to that house at that time. There was no reason to. There was no one to visit. I do understand that Ms. Harrison had the right to cure up until September 17th, 2021, but she did not cure before September 17th, 2021. She testified earlier that after she was told by a judge to put the money into the registry, or that it would be correct to put the money into the registry, that's what she did. But I was not given access to that money. So she could have put that money into the registry before September 17th, 2021.
Objection, that's not part of the record. He can't testify as to what she said, and I believe I objected to this yesterday as well. She never stated, there's no judge order for the money to go into the registry.
But that's what she stated.
He's testifying as to what he is saying his party opponent said. You say that didn't happen. That's why we're at trial. Mr. Harrison, overruled.
Okay. Well, she paid the money on June 9th, 2021, 9 days after our hearing, which was approximately 9 months after the date that she could have cured. At no point in time did me or my family, well, I can't testify for anyone else, but at no point in time did I take anything without permission from Ms. Harrison, under the impression that the things belong to the both of us. But even after she told me that it was in the contract, she still agreed to allow my son to remove property that I had negotiated with her. She never asked for anything to be returned. To this date, she hadn't asked for anything to be returned until she filed the lawsuit.
And just remind me, what property are you contending that she allowed you and permitted you to take from the residence? Is it just the things that were mentioned in that one text message on that one occasion about the three TVs and the sets, or are there additional items?
Well, when I say that she allowed me, would have been because she stated that everything belonged to her based on the contract. The contract wasn't executed to December 17th. The only thing that would have been removed after December 17th would have been on January 21st. Prior to December 17th, we divided cars, we divided artwork, other keepsakes, pictures. All of that was done in November, in early December.
Okay. So you're saying that there were a number of things that you'd already divided prior to the contract.
Correct.
And those are things that you removed from the house
Those are things that I removed from the house.
after the contract.
No, at the time. We divided it earlier and I removed it earlier. I didn't go to that house much. So when we talked about dividing stuff, I met her like on November.
Okay. So, but in terms, my original question was after the contract.
After the contract.
What did you remove from the house? Did you remove anything from the house other than what you mentioned in those texts, the 3 TVs, the refrigerator, washer, dryer, et cetera, et cetera?
The only thing that I would have removed from the house after that would have been when she texted me and told me to meet her that morning. It was still on January 21st. So that morning she said to meet and get this stuff for the aunties. She was going to originally bring it. We were going to meet at the house. She thought I wasn't coming because, I told her I didn't like coming. She offered to bring it to my house, but then I told her I'm here. So it was like some purses and some jackets, some little pieces of art. It was just little trinkets. It was keepsakes type of things.
And you've had an opportunity to review Plaintiff's Exhibit 13, this list of items she's claiming were removed. Were these items things that you believe were ever in the house? Do you recognize this list of items as being things that were actually ever in the house?
I don't recognize any of that stuff. And I would like to get to one of the things, because one of the things that Ms. Harrison has listed on there is that 2017 Nissan Sentra. And I definitely have video that Sentra is still at the house. I have her testimony that it's still at the house. And so that's one of the things that I saw when he gave it to me, which I don't have any longer. I didn't get to keep a copy. He took it back.
Of Plaintiff's 13?
Is that the list of inventory or whatever? Yes.
All right. Well, I think the court reporter would always have one if you need to look at it.
Yeah,
but otherwise, what else would you like to cover here?
I just want to reemphasize that I never told my sister that anything was a mistake regarding the IRA. That was never told to me. That would never be a reason. That would never be something I would tell her. I never thought it was a mistake. The only thing I was, because I thought that we were both joint beneficiaries, which is what was happening with some of the insurance policies. We was actually listed as beneficiaries. So I thought we were joint beneficiaries, but when it came, I'm not sure how it goes with the insurance. But what I learned from the IRA after opening my IRA account with them was that there's multiple primary beneficiaries. I never told her that I felt that it was a mistake. They verified my name, my date of birth, and my social when they called me. With any communication that I had with them, at no point in time did Wells Fargo tell me that. So that would have not have been anything that I told her. However, she felt it was a mistake. She felt that it was a mistake. And she repeatedly told me that.
All right, well, I think we've covered this ground
Okay.
already. What else?
I guess that's it, Yana.
All right, was there anything, I want to give you that opportunity, you wanted to follow up, because that's very important, to make sure we go over this, with the list of items, plaintiffs 13, other than the Nissan, is there anything else you wanted to add about that list?
Can I see a list from the court
Did
reporter?
we have that with the court reporter?
I think it was an electronic.
Okay. An extra copy from plaintiff's counsel.
What number is that again?
13.
Will I be able to show the video, Yana, of the Nissan Sentra at the house right now?
Well, if you've got another piece of evidence you're trying to tender, you can do that, and we'll see where that goes.
I have one. This is from I actually have a stack for you as well. I can let you review it. I reviewed this yesterday. Well, copy.
Okay, this is from Exhibit D2 that was already tendered.
You're pulling something else up?
Yes. I was going to pull up another video, but I want to refer back to the video where Ms. Harrison just admits that they have the car.
For clarification, I would object to the video.
It's already
The
tendered.
damage is not, the claim isn't that, it's for the title. It specifically says title to the car. The name was changed. I don't see a video as the car's whereabouts as being relevant in any way.
Okay, so if
All right, so D2 is being tendered. This is, I don't recall offhand if this was admitted as an entirety or not. I think we have the same, I think this is the one that was used for impeachment yesterday. So are you playing the exact same portion that was played yesterday?
So I'll strike that if he says that this is just for the title, because they put the amount on here for $14,000 like it's damages, and as if I had the car, because this is conversion. So they're saying I converted the car, but he's saying it's just about the title.
Okay.
So I don't need to.
All right.
Okay, so the French door stainless steel freezer drawer, I'm assuming that's the refrigerator that was in the kitchen, which was gifted to my son.
Gifted by.
Gifted by Miss Harrison to my son on January 21st, that she was there while it was delivered to him and accepted to him. And he accepted it, and it's now his. The Maytag top load washing machine, I'm assuming that's the same one. The living room set, I'm assuming that's the same one. I don't know anything about a bedroom set, headboard, mattress, box spring, 2 nightstands. Don't know anything about that. That's not what was gifted to my son. That's not what was removed that day. The flat screen TVs, which she admitted that she gave to Mr. Harrison, to my son. I don't know anything about a Beachcomber bicycle. I don't know that the artwork was, I don't know which artwork she's talking about, but artwork was given. If this was on the 20th, this is what was given to the aunties that she asked me to come over. I don't know anything about Christmas decorations. I don't know anything about gray folding chairs. I don't believe my parents even had gray folding chairs. I'm not sure if Miss Harrison had gray folding chairs. A banquet folding table, don't know anything about that. Reclining sofa, don't know anything about that. A reclining chair, don't know anything about that.
Maybe if it's easier for us.
I could just say I don't know anything about anything else.
But you take your time, take a look through each one of these, and if that's your answer for the remainder of these items,
Okay.
then understood.
The family photos was removed in November. Those are family photos that we agreed. Miss Harrison asked me to give her some copies. Don't know anything about diplomas. The parents' items, the only TVs that we got would have been the 3 TVs up top, which is what was given on the 20th. I don't know anything about any other TVs. My son only got 3 TVs. I don't even recognize these things from my parents. Yeah, I don't recognize any of that stuff, and it definitely was not taken by me. I never had possession of any of that. I don't know who would have had possession of any of that. All of this stuff looks like you would need a truck to take. If that's the case, I would definitely think someone would have video of a truck coming up to take any of this. So my testimony is that I do not know anything about this.
All right. Is there anything else, Mr. Harrison?
No, sir.
All right. Any reexamination on behalf of the plaintiffs?
Yes, Your Honor.
And I'm going to limit this to 40 minutes.
I hope it's not going to be that long. You testified that Ms. Harrison, or as you testified, Marilyn, stated she disclaimed her interest so that she could purchase the property prior to the entry of the purchase and sale agreement, correct?
That's what she told me while we was negotiating. When she brought that contract to my house, she told me that she could disclaim her interest.
But the
After I-
testimony was that she did, correct?
That she did talk to the people and she could disclaim her. If I said did, then that must have been a misspeak. She said she spoke to the people at Wells Fargo and that she was going to be able to disclaim her interest. Because at that particular time, there was no reason to disclaim it to me if we had not had an agreement yet.
You also stated, well, you started your testimony with the contracted issue in this case is a valid buy-sell agreement, correct?
I may have,
And you have confirmed that the contents are contained in that contract, correct?
correct.
You further testified that you'd reviewed all the financial documents and insurance policies that went back up to a decade, I believe. Is that correct?
No, I did not say that.
Your
Went back a
testimony-
decade.
Is your testimony now then that
I-
you did not say that you reviewed the insurance policies contained in the property that went back up to a decade, calling, I believe, your late father a pack rat?
Oh, no, I said there was insurance policies probably going up to 30 years.
Okay, so 30 years. And isn't it true that in those, we'll say 30 years of documents, there were also financial records?
I can't recall what all was in there. It was just a lot of paperwork.
But you recall specifically the insurance policies,
I
correct?
recall specifically the insurance policies because that's what we was looking for my mother. That's what me and my mother and my sister were looking for.
Prior to, so you're saying this is after your father's death, correct?
This is after his death.
And your testimony before that was that you helped with the taxes for your father, correct?
Correct. I filed taxes and
that
I
you
helped
knew that
him.
there was an IRA because there were mandatory distributions, correct?
Yeah, I knew yes. Yeah, I knew there was an IRA.
So wouldn't you agree that if someone were looking for insurance policies after somebody's death, they would, and knew they had an IRA as well, wouldn't they also be looking for records of the IRA?
We were looking for everything. Yeah, we were looking for everything.
So you were looking for the insurance policies and the IRA documents, correct?
We were looking for anything that could help my mother that was there because nothing was organized.
Okay, I just wanted to clarify because.
But it's not you. You keep
Just
saying
stated.
you. I want to say we. You keep trying to say you. And I'm
These questions are based on
clarifying.
your testimony.
My testimony is that we were looking,
You and your mother?
my mother and my sister.
But your testimony is that you and your mother were looking, correct?
My testimony was all three of us were looking. My sister wasn't there all the time, but she was there.
And you testified that you managed your mother's finances, submitted the IRA beneficiary claim form on behalf of your mother, and that you used the same financial advisor as both your late mother and father, correct?
That's not correct.
It's based on your testimony. So I guess I can break it down each one.
You can break each one
You
down.
testified you managed your mother's finances, correct?
I testified I paid the bills. Correct. That's correct. I did pay the bills for my mother.
And isn't it true you submitted the IRA beneficiary claim form on behalf of your mother?
That's not true. I said we submitted it. I can't remember who exactly sent the paper in. I said that we, me, my sister, and my mom sat down and helped her fill out the paperwork because she was hard of hearing. I mean, I can't remember who sent what, but we were all present at the time.
And isn't it true that also that you helped your mother make sure that your father's IRA rollover into your mother's account went through?
What do you mean went through?
Well, isn't it true that you facilitated that, communicating with Wells Fargo in order for your mother to claim your father's death benefits?
No, that's not true. All we did was help her whatever forms that came in. She filled out the forms. And my sister was there, I was there, and my mother was there.
But you specifically communicated with Wells Fargo, correct? Because you previously did testify.
I spoke to Wells
I
Fargo.
wasn't done yet. So, but you previously did testify that you communicated with Wells Fargo and managed your mother's finances, and that you opened your IRA account, and these were all Wells Fargo accounts, correct?
And you asked too many questions, so I don't.
I'm sorry. You previously testified you communicated with Wells Fargo
I've-
when you were managing your mother's finances for this IRA. Not the IRA in our case, just to clarify. When your father passed,
When my
you were
father,
managing your mother's finances.
I was
you
paying her
communicated-
bills. I just testified I was paying her bills.
And that you communicated with Wells Fargo to help with the death benefits.
We communicated to Wells Fargo.
You also testified, gave some various background just about the IRA that you opened and then your mother's IRA and those communications with Samantha Hayes. And isn't it true that all of the accounts have the same financial advisor, Timothy Bembry, or I believe he goes by Tim?
Yeah, I would agree to do.
And it's also true that you had access to your mother's financial paperwork
What financial paperwork?
regarding her IRA.
We all had access to find anything regarding that. It was located at my mother's house. So everyone that was at the house had access to it.
Okay, so then it would stand to reason that you did in fact
I didn't
know
live at
you
the
were
house.
100% beneficiary of the IRA, correct?
How would I know that?
You just testified that it was at your mother's house, everyone had access, correct?
What we did was process my father's IRA. That had nothing to do with my mother's IRA.
I asked about your testimony regarding your mother's IRA.
Well, I need to revise that statement. We helped my mother process my father's IRA. That's the paperwork that we filled out after my father died. My mother had not died yet. So my mother had not passed. So we were not doing anything with my mother's IRA. We were doing things for my father's IRA.
Right, so we covered that. And that you managed your mother's finances. And then moved on. True, right? I asked you a question regarding the IRA beneficiary claim form submitted after your mother's death, right?
That's a question? Can you repeat the question?
I don't believe, so I'm just trying to make sure we're on the same timeline here. But it's that we went through the managing of your mother's finances, paying bills, and then the IRA beneficiary claim form submitted on behalf of your mother, correct?
I testified I did not manage her finances. I paid the bills. That's it. Bills including cell phones and water bills and things of that nature.
You also testified, and this is in quotes, you took over the role as big brother. Isn't that right?
Correct.
So wouldn't you agree then that Ms. Harrison's expectation or your prior testimony even just about you helping her, she's distraught, didn't matter what, what happened, that you would give her half the interest? Wouldn't you think that's reasonable then?
No, I don't think that's reasonable. That someone would think if.
But isn't it also true that in the text messages you presented as an exhibit,
Mhm.
you clearly stated I am taking care of it as usual. And once processed, I will give you your 1/2 since you are my only sibling and I don't feel entitled to all of it.
And what does it say before that? You didn't read the whole text message. Could you please state the whole text message so I know what you're referring
I'm
to?
asking about reasonableness and expectations here. Wouldn't you agree it'd be reasonable if you are repeatedly saying?
I don't know if that's reasonable. I don't know the context of the
Taking the role as big brother. Let's, buy my interest. This agreement is in your benefit. We could have just sold the house. And as assets are coming in and you're managing these finances after both your parents are deceased, then in January, send a text stating, I am taking care of it as usual. And once processed, I'll give you your 1/2 since you're my only sibling and I don't feel entitled to all of it. So wouldn't you agree that you are stating that you want her to have half of everything that comes in?
No, I would not agree to that.
Would you agree that this text message says that you want her to have half because she is your only sibling?
I can't agree to that text message because you're not reading what the text message says in full. So I need to understand the context.
It says, update, the bank forms that you or your children stole, opened and hid was related to stock, which has a cash value. I am taking care of it as usual. And once processed, I will give you your 1/2 since you are my only sibling and I don't feel entitled to all of it.
So I knew it was related to a stock value because I spoke to them and they
I'm not
told us.
asking about the stock, just to clarify.
You are asking about the stock. You're asking about that particular email. That particular text message is related to a stock.
This particular sentence is not correct.
That particular
It says-
text message is related to a stock. And that particular text message is related to a stock that her children opened and hid. And I contacted them and I found out it was a stock. We had to go through probate to get it. So we would split it in half because it had to go through probate, which I still have never seen to this day.
But you do agree that you said as usual, right?
I did say as usual.
So wouldn't you agree then that this is not the first time you are taking care of your deceased parents' finances and splitting half of it with your sibling?
I did not take care of my deceased parents' finances. What I did was reach out exactly what I testified to, that I would reach out to the insurance companies. I sent letters to the IRA. I sent a letter to the Social Security. I sent a letter to the IRS. I took care of a whole lot of that type of stuff. That did not mean I was splitting everything with her. Whatever.
But it's
was,
true you did split.
We split whatever they split. It would come from their part. If I contact you and let you know that my father had died, they determine who the split comes from. If I contacted you, let you know that my mother died, if they had beneficiary designations, they determined the split. I didn't split it because it didn't come to me. All I did was facilitate things because my sister was distraught.
You just mentioned that there's a social security check, but it's true though that you did actually receive that and split it with your sister, correct?
I did not testify there was a social security check. I said I contacted Social Security. You have to stop your social security checks.
Okay. And we can move on from this topic. In quotes, your testimony earlier said, I don't take people to court. But isn't it true that you do in fact, and so much so that a bill of peace was entered against you?
I stated that this is the first time I've had to take anybody to court during this process. That bill of peace is during this process. I stated, I don't do that. There's nothing I have done before. This is not something that I just practiced trying to go to court. This is something that happened, me trying to protect my rights.
But it's true that the bill of peace does not deal with just the case we are here for.
It's during this case, right? It's after this case, correct? It's part of this case.
Isn't it true that it is due to the numerous other actions filed?
During this case, correct?
Yes.
That's what I said. But prior to this case, I do not do that.
But in fact, the first pleading mentioned in the bill of peace was prior to this case. Isn't that true?
As I stated, trying to protect my rights from someone who locked me out the house, which is dealing with this case.
You also testified that Ms. Harrison told you she thought she was a contingent beneficiary.
She said something that he was either contingent or secondary or something like that. She said it was some kind of mistake.
But isn't it true that you actually received an email on November 25th stating that there were no contingent beneficiaries?
Correct. But that's what she claimed.
It's also true that you were pressuring Ms. Harrison to sign the purchase and sale agreement before these IRA funds were deposited, correct?
Can you repeat the question?
Right. Okay, isn't it true that you were pressuring Ms. Harrison to sign the purchase and sale agreement before the IRA funds were deposited?
I never pressured her. I pressured her to either do the deal or get off the fence. Let's sell to Clovey or do the deal. I didn't pressure her. I gave her the option that she doesn't have to do it. I gave her the option that we can always sell. You don't have to commit this, you don't have to commit to something like this. So I didn't pressure her to do it. I didn't pressure her to do it. I just insisted or asked her in a way to make her make a decision, put a little fire up on her.
And wouldn't you agree, based on the testimony you just stated, that that could be viewed as pressuring if somebody were to insist? Or like any of the prior sentences?
It wasn't a pressure her to do the contract. It could have been pressure, as far as you saying it, to actually do the deal with Clovey, which is what was on the table. At that time, we still had a deal on the table with Clovey.
You also testified that this was not an investment property of yours or JLNBL, correct?
I said it was not investment property of mine.
And you mentioned JLNBL in your testimony as well?
I do not recall.
Do you or or isn't it true that you or JLNBL don't have any other investment properties?
No, we don't have investment properties. JLNBL is non-existent right now, so we don't have anything.
I believe this is just your testifying regarding some communications between you and Marilyn back in January. And it's true that you told her that, or repeatedly say to either to her or the police, that you both own the house, that you knew that the IRA had already received 100% of it, and that you, at that point, had never given a notice of default, correct?
Say the question again.
Is it true that or isn't it true that you told the police or Maryland that you both owned the home in your communications?
Correct.
And isn't it also true that in January, you knew that you would receive the full amount of the IRA?
Correct.
And then isn't it also true that you never gave notice, based on your testimony, you did not give notice, despite knowing about the IRA, to Ms. Harrison of any form of default or alleged that there was a default?
I gave her a verbal notice. That was the cause of our argument that day.
But isn't it true that you testified that you did not give notice to her at that point?
No, I didn't testify. No, I testified that I gave her notice in the middle of January, and it spilled over into January 21st is when I'm telling her that she was not a beneficiary, which was part of our argument, which was the heated argument that has been discussed over and over. That was part of why it was heated.
You also testified that, I believe it's in the text messages, March was the first notice of default you gave, correct?
That first written notice, I put it in writing.
And let's go to June of 2023. It's true that after the order on the motion for summary judgment, that you engaged the services of a realtor, correct?
Not correct.
You did not execute, or isn't it true that you executed a listing agreement with a realtor to sell the house?
You said June of 2023, so I don't know.
Let's say July of 2023 or summer of 2023.
No, that's not correct.
After the order on motion for summary judgment was entered, you engaged the services of a real estate agent for the listing of the property, correct?
After the motion for summary judgment in 2022, I engaged in a real estate agent according to the order that was in place that stated that we must sell the house within 30 days.
Isn't it true that without requesting any cooperation from Ms. Harrison, you, after engaging and executing the listing agreement with the real estate agent, listed the property for sale?
I definitely engaged with you because I engaged with you. I sent everything to you directly because I was pro se at that time. You actually spoke to the real estate agent and you told him to not list the house. Had engagement regarding with Ms. Harrison regarding that.
But you had counsel of record after the order on summary judgment came out, correct?
No, I did not. After the what?
After the order on summary judgment.
No, I did not. I was pro se. I was pro se. JLNBL had counsel of record. JLNBL had counsel of record who represented me at the motion for summary judgment. I did not have counsel of record until July, when we were supposed to be having an attorney fees hearing.
Isn't it true that even after the notice of appeal was filed and the appeal docketed, that the property was still listed for sale? Had not been removed?
I can't speak to that. They had to remove. I definitely told them it was an appeal, so I don't know if they still listed it or not. We had to rescind the offer. There was an offer on the table, which you are aware of because I sent it to you.
I'm not testifying today as I'm an.
But I'm testifying that I sent it to you for Ms. Harrison because you are her counsel of record. I had to send it to you.
Isn't it true you actually never, in fact, did have a written offer to purchase the property?
We actually had a written offer which was sent to you.
Isn't it true you presented no evidence of that today?
I'm testifying to that.
I know we covered this. I'm only gonna ask one more question on it, but isn't it true that you testified specifically that it was March 1st of 2021? That was the first time you learned you were the only beneficiary?
No, I testified that on January the 2nd or the 3rd is when she told me via the phone. But on March is when they actually put it, she sent me the beneficiary claim form.
It's true though that when she sent you the beneficiary claim form, or not claim form, sorry, the beneficiary designation form.
Beneficiary designation form.
She forwarded you the November 25th, 2020 email, correct?
She reattached it. I'm not sure how it was. I think it was a forward.
So you just testified that you found out in January, and for the purposes of this question, we can go with that. It's true though that after that point then, according to your testimony, if you knew she was not in or a beneficiary under the IRA, but you still accepted a quarterly payment in March. Isn't that correct?
When that was part of the contract, I had to accept it. Because
And-
she still had until September to make a final payment in full.
But you never informed her of that prior to March, correct?
It's in the contract, so she would be able to inform herself.
Isn't it true, though, that this contract actually doesn't contemplate a scenario where does not have an interest in the IRA?
It also doesn't contemplate a scenario where she doesn't make a installment payment, but it states that if you do not follow the terms of the contract, you will be in default.
Your prior testimony, aside from repeatedly stating you both owned the properties, stated that you knew about the IRA, still hadn't given notice of default at this point, and instead specifically said, you conveyed the property to the LLC. Correct?
I didn't hear a question.
Just made it one.
You asking me multiple things at one time, so can,
It's one question. I'm giving a timer here. You testified that you repeatedly in this, that you both owned the property. You testified that you knew about the IRA beneficiary form, that you received 100%. You testified that in January, you did not give a notice of default. And instead, that you conveyed the property to your LLC.
I did not testify to that. No, it's not true.
But isn't it true you did actually convey the property to the LLC in February?
I signed a quitclaim deed in February.
So wouldn't you agree that that would be a conveyance?
Yes,
And in March, though, you still accepted payment, correct?
as a party to the contract, I accepted payment because that's what the contract stated.
And in March, you sent the first written notice of default, correct?
Correct.
And you're based on your testimony and I believe the text change that are of record. You individually retained counsel to send a letter of default in, is this April, correct?
I don't, yes, April.
I don't think I have anything further, Your Honor.
All right, Mr. Harrison, anything else that you want to testify by narrative in response to anything that came up during that recross?
I just want to clarify the points that Mr. Lettermeyer is trying to distort.
I would object.
I
to
did
the
not-
Classification of our allegation that counsel of record is attempting to distort.
Mr. Harrison.
I did not know I was the beneficiary until January. I did give Ms. Harrison a verbal notice that she was not the beneficiary in mid-January. I gave her another notice, verbal notice, on January 21st. Written notice of default came on March of 2021. Second written notice came in April 2021. I did convey my interest via quitclaim deed to my LLC, which was to adhere to all the terms of the contract. I did accept payment on March 2021. I was still a party to the contract, and right now I am the sole owner. Well, I am the LLC has been conveyed back to me, conveyed the interest back to me, so I stand in the shoes as of today, and we are still dealing with the exact same contract. That's all I want to say.
All right, you can step down then, Mr. Harrison. Plaintiff may call the next witness.
I think the only thing I need to do is stand in my place and state attorney's fees. I'm trying to get them as current as possible. I've already removed everything through the end of August, so it'll just take me a second.
I think it would be also worth noting, I see in the bill of peace, Mr. Littlemar, that you were awarded attorney's fees as it relates to that. So I think it'd be worth noting if there are credits or offsets or something along those lines.
They've never been paid, Your Honor.
Okay, but even if they haven't been paid in that case, I don't think you would be entitled to them in this case just because they haven't been paid.
Right, no, I've already gone through and removed. I'm gonna have to get a new exhibit for our the line items now that I've redacted, or removed those fees. But yes, I actually removed approximately $21,345 related to the other magistrate court hearings.
All right, and well, feel free just to present your evidence if you want to detail why or why not you think those should or should not be redacted. Feel free, you can just make your record.
Oh, no, I don't believe that they need to be redacted. I believe that they'd be entitled to be cross-examined. I'm just saying that I had to go through and manually, because I can't access everything in VPN through an unsecured network, and manually remove them via Excel. So I just am gonna have to go back to the office, I guess, and send a supplemental exhibit. I mean, I can email the spreadsheets that are broken down into the three, myself, the partner of our division, and then paralegal who worked on this matter.
All right, let me just from the top. You've got an exhibit with your attorney's fees on it, but now you're saying it's not the one that you want to tender into evidence.
Yes, Your Honor, because it included the magistrate court pleadings. It actually, this one, for some reason, only has the ones that, it only has entries from me, which I'm not sure why. I have the spreadsheets pulled up.
I'd like to object, Your Honor.
I mean, do you have an exhibit to tender today for trial?
Would you be amenable to tendering it digitally?
I think if we can get that to the court reporter, that's fine. If it's something you need to alter in some way, I think you could also just submit what you have and then say why, what portions of it you need to alter.
I've gone through, I pulled out, I did reports from our actual billing system and pulled out a spreadsheet for each party. So myself, the partner, and then paralegal. So I have them pulled up. I can send it to the court reporter or email it to and Mr. Harrison if you want.
Just email what you want to tender and make part of the record, and we'll go from there.
Okay. And then would you like me to add, well, I guess I can or leave, stand in my place and add estimate today up to this hour, I guess. Sorry, the internet is being very slow. Sorry, Your Honor, I'm trying to work on two systems at once.
No, taking restroom breaks.
Okay, finally have it. So this does not appear to include court costs.
All right, Mr. Lidemeyer, it's trial. I don't know why we don't have exhibits ready.
Sorry.
So you can present what evidence you have and let's move forward.
I just emailed the 3 actually reports. Each party is broken out individually. Since I was the primary attorney who worked on this, the other ones are nominal, and then I was just gonna pull up the actual court costs as well.
All right, we're back on the record. So you have emailed certain documents to Chambers and Mr. Harrison?
And the court reporter as well.
All right, and are you tendering those documents?
Yes, I am, and then I can stand in my place and
As what number?
as to the cost, this. No, we haven't looked at. This would be, I guess, plaintiffs 14.
Plaintiff's Exhibit 14, which is a breakdown of what exactly?
These are a breakdown of all fees to date. I have the Excel spreadsheets I sent over. Anything related to a magistrate court hearing has been removed. The record would still show, but the time and amount has been zeroed out and the dollar amounts removed from the grand total. Did you receive those?
Yes.
Okay.
All right, I know you may have just received these, Mr. Harrison, so you probably haven't had time to review them just yet. Right now, based on a preliminary just viewing of them, any objections for the record you want to place or note? I'll allow you to supplement that later.
I do have an objection to party to the action. I mean, he's trying to get attorney fees for, he stated that. I'm trying to go through them. He put these in an Excel sheet.
I can probably convert that to a PDF if it's easier. And if Your Honor would like, or any of the parties, like, it would be the same document. I can just have it converted or.
I think that's going to be cleaner for the record. So to finish that thought, Mr. Harrison, what's the basis of your objection to these documents?
I'm not sure, you stated earlier that about the bill of peace, fees for previous actions dealing with parties, there's not a party to this.
So my understanding based on what he said is that anything not related to this court proceeding specifically, he has zeroed out the amount. So I believe that bill of peace was sought in a separate action. And so my understanding is that would not be part of his sum total. Is that correct, Mr. Lidemeyer?
Yes, Your Honor, sorry. The only times that there is a bill when it might say bill of peace is when and this is admissible for attorney's fees. It was when we were negotiating settlement and it was a contingency. He wanted the bill of peace either, withdrawn or the attorney's fees amount credited to any amount we were going to settle at.
Okay, so these kind of line by line things, Mr. Harrison, those are going to be more things you can argue about. You can follow up on if you want to have clarification questions. But in terms of the admissibility of this document, that's what we're kind of getting at is the threshold issue. If you have any objections to note concerning the admissibility of this document.
I don't have any.
Okay, so for the record, we'll have Plaintiff's Exhibit 14 is admitted. And Mr. Lidemeyer, if you have any thing to follow up with stating in your place, you can do that now as well.
Yes, I can also have so I could have just my paralegal send over to everyone a combined document of every single true invoice as opposed to this fee transaction listing, which has costs on it as well. It's just our bills, of course, for September would not include or not be there yet because we bill in arrears. It's
You-
really the court first. I mean, I'm tendering these as these go through today, or technically yesterday. I can stand in my place and state today, so I bill at an hourly rate. Currently, actually, my hourly rate is $3.75, but for this case, since it is so old, my rate at this case was $275 per hour. I have been barred in the state of Georgia for just over 9 years. And this is standard and customary in practice. And these fees are standard and customary as well, given the extensive litigation that has gone on. The managing partner of our division, Tanya Tuttle, which the initial would come out as, I believe either TRT or I think TRT, there was. Yeah, unless it would be TRT. Her rate, again, is not the same now as it was, and which would stayed consistent on this case, was $375 per hour. She has been practicing for over 20 years. The rate is standard and customary, and as well the fees. And then my paralegal on this, Darcy DeFrucio. On the statements, it would reflect as DAD. She billed at $125 per hour. I know she's been a paralegal for over 25 years. That rate is standard and customary.
All right, so what's the total amount?
So the total amount was, oh, I'm sorry, and okay, yeah. So the total amount of costs, which would include the managing partner, Tanya Tuttle, myself, and our paralegal, plus the court costs, which were $6,463.84 to date. And that actually would not include anything filed in the month of September. But for the purposes of this hearing, and we are at trial, I have no way to add that in. So that aggregate is $171,098.84. After reducing the fees attributable to magistrate hearings, which were $21,345, the total amount is $149,753.84. And, you know, as you will see in by the docket alone, there are a lot of pleadings. There's been a lot, it's been a highly contentious litigation. This is actually, yeah, one of the longest litigations of, that I have personally done between siblings, that it has been so contentious over a property such as this. I know personally that I reduce on many occasions the fees in this case because they've gotten so high. We even had that one award in the Bill of Peace for the $7,500, which was never received. The settlement negotiations in this case were going on off and on because there was various counsel involved, but when Lewis Levinson's firm was involved, back and forth for months. And it was a lot of back and forth. The settlement agreement was extremely extensive. Mr. Harrison himself made that portion of these fees even more extensive because he wanted the funds to go to him, not his law firm. They ultimately withdrew. Settlement fell apart after the Court of Appeals order came out, and I don't know if there are any specific questions you have. To be fair, I've never actually stood in my place to.
All right. Well, my understanding of that is that yes, well, it doesn't happen often. Opposing party does have the right for any follow-up questioning related to the fees. So, Mr. Harrison, do you have any follow-up questions for Mr. Liedemeier? concerning plaintiff's exhibit 14 or any of the fees?
I believe those are definitely excessive and unreasonable.
Oh, actually, before you respond, can I amend that really quick? Because that does not include today, which would be an easy calculation. It's 417. Let's see. So that would be an additional $1,925, which would be 7 hours. We're actually a little over that, but so the total is $151,678.84. Which, yes, I know as Mr. Harrison stated and is likely to, again, they are high. But I believe that you've seen the course of this trial and we've had numerous hearings on, just on this case alone. Switched judges as well, but we had not just one hearing on the summary judgment. We had two or possibly it was three. I'd have to go back and look. There were issues without Mr. Harrison had technically filed bankruptcy and gave no notice to the court. And so once that was discovered, further increased fees. So yes, it is a lot, but I stand in my place and do stand by these fees as actually a reduced amount of what this case could have cost Ms. Harrison.
All right. So, Mr. Harrison, I'm not so much looking as your opinion on them, your characterization of them. You'd have full right to explore that and argue that in summation. It's more so, is there anything that you think needs to be brought out or clarified through questioning of Mr. Ledermeyer?
Fees are just for this case alone.
So what I emailed you will have everything. What I just said when I stood in my place and said that the 151,000 is just this case. I reduced $21,345 in fees from the other case, or the other cases, the magistrate. Now, that includes the attorney's fees and $6,463.84 of court costs, which would be the filing fees or ordering title or whatever the costs associated, the actual cost we had to pay vendors.
I guess I have no other questions.
All right. Any other evidence from the plaintiff?
Potentially, I'm trying to make, I was just reaching out to the firm. I mean, I know I stood in my place, I just sent those, I just, for a clear record and to tender into evidence the true invoices, which yes, would only go through August, and these would be additional evidence of current fees. But they are trying to get that, a combined single PDF of that right now.
All right. Those essentially are just going to be duplicative of what you've already outlined in plaintiff's 14 and through your testimony. Is that right?
Yes, it is, Your Honor.
All right. Okay. Any other evidence to present?
No, but once we receive these, would you like me to tender it as a different exhibit or as a combination of this exhibit? Or do you even want it tendered?
I think at this point, we need to close the record. And so I think we have to leave it there. All right. So, Mr. Harrison, plaintiff has rested. And so do you have any motions or evidence you'd like to make on your behalf? I know you've already kind of given your direct, and I treat that as part of your case as well. But how this works is they go and then you go, even though there's been a little bit of both on their side of things. So any other evidence or testimony on your behalf?
I'm not able to submit my attorney fees without my attorney being here, correct?
Well, it would be challenging to do that without your attorney here. You have to prove again the hourly rate. You have to have all the documentation. The attorney usually has to say there are a lot of things that they'd have to satisfy for you to be able to meet that. That's hard to do by yourself. All right. So with that, then we'll consider the evidence closed in this case. Because of the late hour, I don't know if we would have time to finish summations. And so, I mean, I'll just ask preliminarily, how much time would you expect to, Mr. Liedermeyer?
For closing argument,
That's right.
I'd like to keep it succinct for you, Your Honor. I know you've had enough of us, enough time with us. I would say no more than 15 minutes, possibly. I mean, this.
All right, fair enough. And Mr. Harrison, how much time do you think you need?
Okay, maybe I'm wrong. Actually, I don't know. I've never.
15 minutes sounds a bit optimistic, but we'll see. Mr. Harrison, how much time do you need?
About 15 minutes.
Because my thought was we can always come back and finish this up on Zoom tomorrow, if you would prefer. Apparently, they're shutting down the courthouse tomorrow. I'm just getting word here due to the weather. But just so people aren't feeling rushed, if there are no concerns with the parties, again.
Oh, I was actually informed that my closing would be 30 minutes. I apologize, Your Honor.
Who's informing you of this?
The managing partner of our division is probably watching the live stream.
Okay, got it. Maybe he'd like to join you for that. I don't know. Interesting. Okay, so regardless, I think then the best course here is to come back tomorrow. We've got some criminal calendars we're taking care of, but we could resume, I think, somewhere in the neighborhood of 2:00 by Zoom. Is there any concerns or objections to proceeding over Zoom for summations tomorrow, Mr. Liedermeyer?
I have no objection to proceeding over Zoom.
Okay, Mr. Harrison? All right, so that's the tentative plan. If the timing changes, do you think our court reporter can join us that way as well?
Concern I wanted to raise, Your Honor. I was only scheduled to be on this trial for yesterday and today. So if that is the case, they may just need to reach out to my litigation company.
Do you know offhand if you have a conflict already?
I do. I have
Okay.
a deposition at 10 a.m., but I don't know if they'd be able to move around my calendar or be willing to. It just all depends.
Sure.
It is pretty late though, so I'm wondering if.
And if it sounds like for this entire thing, we only need to allot about an hour, we could also push it to after your deposition or something like that. So let's just all figure it out through email between here and there. And we'll go from there. In the meantime, I kind of want to, I understand, I think I understand Mr. Harrison's, it's a pretty straightforward counterclaim of breach of contract, what he's asking for. I guess just by way of allowing me to think through some of these issues in advance, Mr. Liedermeyer, I want to make sure I understand your legal claims here. And I just kind of want to get an idea of exactly what is it that you're asking for at this point. I know you're saying that the terms of this contract, are you saying the terms of this contract, the unambiguous terms of this contract, conveyed 50% of the IRA interests from Mr. Harrison to Ms. Harrison through this contract?
I'm saying that, well, I have several theories on it that I believe as a matter of law, the evidence would support, yes, the either disclaimer of interest, gift, bequest, ratification, acquiescence. There are numerous doctrines that I believe would apply in this case. I think having the knowledge and entering into the contract, the contract is read by its four corners, except parallel evidence would be admissible for consideration specifically between siblings, which we cite, well, not, I'll cite in my closing for you, but in our motion for summary judgment, I know it is cited. Between siblings especially, but there is the evidence is, I believe, shows that Ms. Harrison was defrauded into entering into a contract that Mr. Harrison knew he could collect cash payments from and then place her in default to sell the property. And I think that that's simple as it is. She's choosing.
Oh, sure, but the remedy for fraud would generally, as I understand it, be contract is rescinded or you get specific performance
Right,
under the terms of the contract.
correct, which is what we brought a claim for, specific performance. And as this case grew and the evidence grew, of course, more information came out, but I believe we are specifically performing it. The interest might, what is her interest? It's been challenged. That would be, I believe, the only ambiguity that would allow for, well, consideration. There is case law that does allow for parallel evidence to be admitted. Contents has already been admitted as being part of the contract and contemplated or in the order of the Court of Appeals. But yeah, for this case, I think it's just what is the interest? And at the end of the day, it doesn't matter if she was a beneficiary on the designation form or not. Mr. Harrison knew before the first draft of the contract and told her, I would give you half and we'll fix it. It must be an error. Everyone has the same name in this case.
Sure. So I guess what I'm getting at here is if your theory of the case and you believe the evidence shows that there was a fraud committed where Mr. Harrison knew that she didn't have any right to any of it, how can you then also say that it's a gift and that the mutual intent of the parties was that he convey part of it? It seems
It's
contradictory.
Oh, I'm sorry, Your Honor, I didn't mean to interrupt. It's at the time they entered into the agreement, she had conversations with Wells Fargo. They told her she wasn't a beneficiary. Whether or not she understood it isn't relevant. I think when they entered into the agreement, that part is the intent was either from Wells Fargo as a beneficiary or from Mr. Harrison, who chose to give her half. His interest had vested. Then there is a fraud after the fact when he's trying to place her in default and order the sale of the property, or unless she gives him the IRA within 10 days, when he knew about it the whole time. I think if she's been defrauded, we have the right to enforce the contract on its terms.
But the fraud has to occur at the time of the contract's made, right?
Right.
So what I just heard you say is that now you're saying the fraud didn't occur until afterwards or at the time of making the contract. Your theory is he did know, and that was the fraud.
I think there's more than one instance of fraud, but yes, I think he did know.
Okay.
And then he's pushing her to enter the contract, but at the same time is also the evidence showed that they're communicating. It's you'll get your half, don't worry about it. I'll take care of it. There must be a mistake.
So what I come back to though is if it's that he did know at the time he made the contract that he had 100%, how can we then say that this contract and the meeting of the minds here was that he was conveying 50%?
He said, or repeatedly said, I'll give you 50%. He did know. She might not have or might not have understood, but the promise to give her half and then the ratification of that by accepting the quarterly payment, or sorry, the immediate 30,000. Then he accepted a quarterly payment and then consents to the TRO after things became more contentious with them. It's a ratification. He's stopped from saying that he did not promise her that interest and stopped from saying she can't enforce this agreement or that she's even in default. If he knew the entire time, it should bar as a matter of law his arguments or even ability to place her in default. He can't challenge the contract. He knows he entered into it. He's repeatedly testified it is a valid enforceable agreement. The question about the IRA, and yes, this case is complicated, but he wrote the terms into the contract. Ms. Harrison's interest. I believe it's the first paragraph where it talks about how payment's going to be made. It was an upfront payment of $30,000. Something about, I'd have to pull the contract up. Ms. Harrison's interest. Well, if he already knew she didn't have one, then he just gifted her one by contract. If that's a credit towards her purchase, it's her interest. If he knew she did not have an interest, then the only other answer would be that he gave her an interest, disclaimed it, gifted it, later ratified it. And and again, we'll go over it.
Well, I mean, I think I'd like to read some of these cases in advance because I'm struggling to understand the legal route there, that even if your argument is that he knew at the time, I'm struggling to see how this contract is one that I could read to say that this is a gift when it's really not explicit here. It's basically just saying I'm going to get paid and here are the ways that I'm going to get paid. And so if it ends up being that this IRA is not worth anything, then the 130's got to come from somewhere else. As long as it's all due by September. I'm going to need to see something of how fraud transforms this into a gift. I'm not seeing that connection.
Well, there's the fraud and ratification argument, but here he already knew the exact amount. They were guaranteed death benefits. It didn't, I mean, even the father's IRA funded higher than its market value was at the time because they're guaranteed death benefits. So he already had confirmation of the amounts in communication with them. So the amounts aren't in question. He has put in detailed calculations for if it is 32 versus, I think it was 154, it actually funded higher than that, but then it's X, Y, or Z. So he had it was confirmed. There wasn't a question of that there is a value. It was, is it one amount or a higher amount? It ended up being even higher than either contemplated, but so that means he knew about it, knew she's not a beneficiary, and credited her with that portion. Even stated this contract is for your benefit. There are all the texts and the testimony, and everything was for her benefit. He said he could have sold it and gotten cash up front. So I do think that the evidence would support it being a gift.
All right. Is there any particular case that you consider your strongest that you think I should read?
With regards to a gift?
I think so.
Yeah, that's the other thing is it doesn't contemplate her not receiving an interest of the IRA. It just contemplates quarterly payments. I think my brief on our motion for summary judgment is, it does cite great cases. I mean, some of these are, so Lowry v. Fenzel, it's a 2015 case. That's actually, I believe, in divorce where they had entered an agreement and operated to waive her beneficiary designation. Young v. Stump, 2008 Georgia Appellate Court opinion, parties contractually waived IRA beneficiary designations. Cruz v. Todd is the same. And my brief from MSJ goes through that the record showed in January, which we read the text about, I'll handle it as usual and give you your half. You're my only sibling.
All right. Well, I'll take a look at that.
I can give you this copy of my brief if you want.
Sure.
Or if you prefer digital, I'm sure you have free access to it.
All right. Thank you. All right. Well, just wanted to get a head start on some of this. I would also say, though, that I would include as part of your argument an alternative remedy of if what you'd be asking for if I do not find that either the contract language itself or the surrounding parole evidence indicates that this was a gift. So I'd be curious to hear what you believe the plaintiff is still entitled to in that factual scenario. All right. Mr. Harrison, I know you've been sitting there quite patiently and quietly. I was just more trying to engage in some of these legal arguments and or anticipate some of the legal arguments of counsel, since we hadn't really fleshed a lot of those out, and I didn't have the benefit of the motion for summary judgment hearing or the briefing. So if there's anything you want to add or talk about, otherwise we can also get into this in the summations if we're able to schedule those tomorrow, court reporter permitting.
Don't mind just getting into the summations tomorrow.
All right. Sounds like a plan. All right. Thank you all. We'll be in recess until a time to be determined tomorrow or thereafter.
Thank you, Your Honor.
Thank you.
Ms. North, which I see in your card